Item number 1 and 2.
Read petition dismissed.
Stay of operation of the order.
You know, Learn and advocate appearing on behalf of the petitioner prays for a stay of the operation of the order. As from the inception there was no interim order, I'm not inclined to accede to the prayer advance. As from the inception there was no interim order, I'm not inclined to accede to the prayer advanced by the petitioner. Today.
Yeah.
দুটো করে দিয়ে আপলোড করে আর কোথায় আর কি সামলাবে একা পারবে আর
Item number 1.
না একটু মেনশনটা ওদের করতে দিন you have given the mentioning slip on Monday it will come sir, don't worry, don't have to give, it is already there দেওয়া আছে তো গুলো extension গুলো তো I have not added anything sir. Upgradation matters will be added from tomorrow only. নিয়ে নিন ওটা যদি আগে দিয়েছে বলছে the second time if it goes to the department again will file will go from here again come back. You are sending this, he will not check, he will send this requisition to the department directly. This is a hearing no tomorrow only urgent matters, not all matters. Then I will stop mentioning. So only urgent. Tomorrow is the date for mentioning. Only in case of urgency, I am allowing accommodating. Not today. See the list.
Permit to mention, my lord, local club, my lord, petitional land, include, my lord, entire, my lord, and my lord started the Doljatta Mela, my lord, they are not enter into their land, my lord. Local club, my lord, enter, my lord.
For what? Mela for what? দোলযাত্রা মেলা তো আরম্ভ হয়ে গেছে আর কি এখন you want to stop এ বাবা মহা মুশকিল স্টপ করা যাবে না করা যাবে না all local people are involved over there. You file it, I will consider. I will file already filed. When is the matter supposed to come normally? Tomorrow to ki hobe tomra if it let it come tomorrow, Monday I'll take up. For next year I'll pass a direction. What is the urgency?
Even after civil judge immediately directed the commission
to the file it will come, sir. These are the matters taken up regularly. Why should it come out of the way? File it will come up, sir. আবার মাঠে কোনো ম্যাটার নেই আর after that everybody was next week it will be taken up. Yes sir,
I'm mentioning item number 70 of today's list, my lord. The difficulty is I have filed this matter on 3rd of February. Since before 3rd of February, there was 9 complaints before the police officers. The main perpetrator here is a local councillor of Trinamool Congress, my lord. And
3rd of February you have mentioned.
I have filed.
File over here.
I filed the matter, my lord.
In High Court.
High Court. And after 3rd of February, the SI is calling me.
So why after so much time the matter is 3rd February or 3rd March? 3rd February মামলা আমার
I stand corrected. 3rd March.
that is
My lord, 3rd March I have filed. After 3rd March, my lord, what is happening? The local councillor with the SI. I have recordings of the phone number of the
sir,
phones, my lord.
I'll take it up,
But
sir.
he
Please
says
wait
that
for some.
he has taken into the
I'll take it.
financial problems of all the judges and all whatever nonsense things he is saying.
We'll see, sir.
My lord,
Let it come.
my lord,
Not today.
my lord, the family
Not
is
this
not in a position to stay in their home.
Monday you mentioned if it's not
But
taken
we
up.
only appreciate he is not in a position to enter
So
his
we have
area.
very limited time. These 2 days, you understand.
My lord, will likely to appear Monday in the
Monday it is in the list. It will be called, sir. Let me proceed with the list. Monday. কোনো inclusion হবে না। Monday. I don't know what how is it organized. I will check up today in the evening what is the condition. If it is it can. You will do half a day job, sir, and matter will be in the list. So I understand that. We'll see. চলো ডাকো Lisa. We'll see. Give the learned advocate appearing for the petitioner. As per instruction of his client, do not intend to proceed with the present writ petition. Learned advocate for the state, who is there? Only. Learned advocate for the state as well as the Kolkata Municipal Corporation is present. In view of the petitioner expressing his desire, comma, WPA 29839 of 2024 is dismissed as not pressed. Written instructions submitted by the learned advocate on record of the petitioner be kept with the record. কি হলো দুপক্ষই নেই where is Mr. Shopon Banerjee দেখো and where is Mr. Rajdeep Mojumdar or Moik Mukherjee? Nobody is there. হয়ে গেছে মিছিল একটা কষ্ট চাপিয়ে দিই তাহলেই হয়ে যাবে
বৃষ্টি হচ্ছে না ওখানে ভোট শো হচ্ছে না কেন শো হচ্ছে
You have any report, madam? You have any report? Oh. So where are the other advocates of the state?
আবারই হয়ে গেল শো করেছে এবার শো করছে
এটা একটু পাসওয়ার্ড রেখে দিন ওই আছে ইনফর্ম মিস্টার ব্যানার্জি অ্যান্ড মিস্টার ময়ূক মুখার্জি এটা পাসওয়ার্ড রেখে দিন শেষ করে দেবো এগুলো কিছু নেই Yes, state you are appearing. Yes. Where is he? Where is Mr. Shahi? Yes, sir. What happened?
On 6th of
Use the microphone.
on the 6th of October 2024, the petitioner was an FIR was lodged taking the petitioner under section 406, 420, 506, and 34. Well, the petitioner was once served the notice under section 35.
35(3). Then what happened?
Kindly come to the page number 33.
What are you wanting now?
Without serving
And when you see the complaint which was served upon them by the
they
petitioner.
arrested the petitioner.
You are who? The complainant or the accused?
Accused person.
file the complaint, madam. You are several 2025. Kindly come to the last page of my report, madam.
But police has arrested the petitioner by violating the judgment of the Ernest Kumar versus State of the Bihar. They have not yet served any notice, my lord.
They did not return to the complaint the rest of the total amount given by the complaint. So they alleged that vehemently demanding the accused person's fate.
Once the petitioner was appeared before the police station, along with all the documents, police has not received.
Taken on 16/11 and the state high of
But
further
then
issued a
they
notice
have
of
arrested the
the
petitioner.
with the accused with the direction to we to late from the day 8 when the cause of action. The petitioner is aggrieved by the fact that the information which was furnished with the English Bazaar police station was not acted upon. Acha. The main allegation of the petitioner relates to certain two forgeries having been done in respect of his signature. Full stop. According to the petitioner, a cognizable offense is made out, yet the petitioner yet the police authorities did not take any action. State has submitted a report which reflects that the petitioners were petitioners. The petitioner was what is the other case number, madam? 1431. Petitioner was arrested in connection with English Bazaar PS case number 1431 of 2024. To that effect, notices were issued and
March 2025.
they could gather evidence. That is another case. But this particular case, where he was arrested, is 1431 of 2000. Acha. You will know? To that effect, notices were issued, and subsequently, the police authority is compelled to arrest the petitioner, and finally, on or about 9/12/2024, the Honorable High Court was pleased to release the petitioner on bail. After release, the petitioner has has filed the complaint, which, according to the police authority, is for the purpose of circumventing the procedures of law and to build up his defense. Full stop. It has also been reflected in the report that another complaint was lodged was received by the police station on or about 5/3/2025, and a case being English Bazar Police Station, case number 370/25, dated 5/3/2025, has been registered against the petitioner. Full stop, be that as it may. The grievance of the petitioner is that his complaint has not been acted upon. In case the police authorities are reluctant to act on such complaint, petitioner will explore the possibilities of approaching the jurisdictional courts for reliefs as provided under the statute. We therefore say aid observations. WPA 134 of 2025 is disposed of. Reports are submitted. We kept with the record server copies. Chalo.
Can I get a copy of the report?
How can you? You are an accused. Same. This. Same.
Affidavit of fact, I will see.
Same case.
Same case. Where is the different version?
Secondly, to conduct department. This is illegality in arrest.
Yes, my lord.
You file an affidavit, sir. Illegality in arrest, I have got to deal with that. I cannot dispose of it. That is something different. Earlier case is something different. Illegality in arrest on a report, I cannot do it. You have got to deal with the accusations. You file an affidavit in opposition. I'm granting you time. You are respondent. You can also file your affidavit in opposition. I have got no issues. But state will file the main opposition. Whether there has been any illegality, I'll consider that. Let them file reply at the time of hearing. I'll consider. Because this has got nothing to do with the previous case. Previous case was completely different.
Yes, my lord.
চলে আসুন তো I understand he has challenged the illegality. That's a question, different question of fact totally.
Yes,
That has to be denied by the state, and in what manner. Thereafter, it can be decided only. চলে আসুন you take back the report, sir. The subject matter in the present, এটা একটু ফেরত দিয়ে দিন না state কে ফেরত দিয়ে দিন. The subject matter of the present writ petition is in respect of an arrest of the petitioner. Since the prayers are since the prayers which have been advanced cannot be decided without exchange of affidavits, I direct the state as well as the private respondents to file their affidavit in opposition. How much time you will take, sir? State 3 weeks. কত 12 19 26 by 4th of April. By 4th of April 2025, affidavit in reply by
1 week.
by 11th of April 2025. List the writ petition under the heading hearing in the third week to দুটো দিন আছে, in the 4th week of April 2025.
Hi. Hi, Malay. I am for the petition.
Yes.
This matter what happened, my lord, the petitioner.
Position of amendment.
Yes.
Different is saying. What
Yes,
my
yes.
different is saying, I don't.
Yes. Yes.
This
Yes, you say.
is the petitioner has got the land by way of a settlement as a landless person. And the same was duly recorded in the name of the petitioner.
What will the police do? Tell me.
Thereafter, due to regular disturbance, the petitioner filed a civil suit. There is an order of injunction. In spite of that, the private respondents are regularly disturbing in regard to the petitioner's peaceful position and plantation of trees. My lord, kindly come to page 21.
There is any 151 order.
No. Yes.
151.
Order 39, Rule 1 and 2.
Subsequent, any direction upon the police authorities by the civil court?
No.
Make that application, thereafter police authorities will act. Chalo. Petitioner claims that there has been unnecessary disturbance and interference committed by the private respondents in respect of peaceful enjoyment of his property, particularly with regard to plantation of trees, and the same is in spite of an injunction order being passed by the learned civil judge.
Junior First Court at Bahrampur.
Learned civil judge, junior division, first court, Bahrampur, in TS 349/24. Full stop. State has submitted a report. The report reflects that the police authorities have drawn up proceedings under section 126 of the BNSS. Acha. It has also been pointed out that the next date of hearing before the learned aid civil court is on 7/4/2025. Learned advocate, you are the private respondents. Learned advocate for the file your affidavit of service. Learned advocate for the private respondent number 8 submits that the nature of the dispute complaint of is a civil dispute. The civil court is already in session of the matter, and if the petitioner is aggrieved by any violation of the order, it is for the petitioner to approach the jurisdictional civil court with appropriate with proper prayers. Next, I've considered the prayers of the respective parties, and on an assessment of the same, I am of the view if the petitioner approaches the civil court with direction, with a prayer for direction upon the police authorities, and the civil court is pleased to pass necessary directions, the police authorities would respect, obey, and implement such order. In the meantime, police authorities would ensure that there is no breach of the peace and or tranquility and or any untoward incident resulting from the inimical relationship existing between the parties. With the aforesaid observations, WPA disposed of the reports are submitted, be kept with the record. A copy of the report be handed over to the learned advocate appearing to the petitioner. এটা কি বিল এন্ড আবার কি কাগজ দিয়েছে যেরাম আছে দেখে নেবেন আপনি, প্রত্যেকটা সেন্টেন্স এক হয় না। আমি তো আমার মতো বলে যাচ্ছি, আপনার যেরকম কনস্ট্রাকশন দাঁড়াবে সেই অনুযায়ী করে দেবেন। Yes, what happened? কি চাইছি? To take immediate action against the
I'm giving out my husband, my lord, from my own from the room, my lord.
So you have a dispute. Any case pending?
Any case, no case, my lord.
No case in PWDV you approach, sir. How can police authorities interfere in this domestic?
My petitioner, my lord, not
Huh?
file any application because, my lord, his intention is only to stay his own house, my lord.
The state that is under PWDV Act, you go. You are the wife.
Yes, my lord.
Properties of the husband or the shared household. Why will police authorities interfere in domestic matters? চলে আসুন। You have a report or no? ভালোই আছে। Petitioner is agreed by
Only, my lord, not to disturb my person, my lord.
তাহলে তো বাড়িতে আছে তো।
But certain time, my lord, only, my lord, certain time, my lord,
Very good.
I
Petitioner
know, my lord, I have already narrated already fact, my lord. My lord, certain, my lord, only, my lord,
not under
only, my
226.
lord, to
Sir, not under petitioner petitioner has approached the court as there has been inaction on the part of the
well, that is my main point, my lord.
your main point is the representation. That I will not direct, sir. Concerned court will direct. এই যে শুনুন বেকার মামলা বেড়ে যাচ্ছে, 40টা 45টা করে ফাইলিং আরম্ভ হয়ে গেছে, তো আজে বাজে
Well, my
যা হোক করে একটা ফাইল করে দিয়ে পুলিশের চিঠি দিয়ে ফাইল করে দিচ্ছে, ল্যান্ড ম্যাটার হোক যাই হোক।
well, that is main problem is, my lord, petitioner is not willing to file any application because, my lord, But
petitioner can come to High Court, will not go to the trial court. হয় নাকি যেখানে যে আইন petitioner is agreed by the fact the representation
not to divine out, my lord,
Huh?
on certain time, my lord.
police authority is as the information furnished on 6/1/2025 with the Dankuni police station has not been acted upon. Full stop. Petitioner complains that the husband is trying to throw away the petitioner from a residence, and and she is unable to stay because of such disturbance and interference. Full stop. Since the prayer of the petitioner before the is court for assistance from the police authorities to stay in her matrimonial house. I am of the view that in case there is any issue relating to her staying at the said residence, petitioner would approach the jurisdictional magistrate under the relevant provisions of the PWDVA Act 2005 for residential rights. Full stop. Learned advocate 8 for the respondent number 7 to 13 is present and submits that there has been in occasional incidents, be that as it may, since the nature of evidence service meaning
Husband might refuse, my lord.
ওটার সাথেই তো ওটা থাকবে be that as it may, since the nature of the cause of action is the absolute domain of the learned magistrate, if an application is filed, the same be considered at the earlier age by the concerned court. Police authorities will interfere only after specific directions are passed by the learned magistrate. With the aforesaid observations, WPA 4478 of 2025 is disposed of. Server petition. Report নেই এই যে আবার কি
My
report?
lord, I pray to appear. My lord, I
Yeah.
pray to appear on behalf of the petitioner in item number 7.
Yes.
My lord, here the petitioner is aggrieved by the gross imprudence and impropriety in the action of the police. Lordship kindly comes to page number 34 of my petition first. That will show you, Lordship, the extent of injury that had been endured by the petitioner number 1 at the hand of her in-laws at the matrimonial home where the husband was not present. Now, my lord, she was hospitalized for about 8 days subsequently. In the meantime, a complaint had been made, case had been started. Now, the problem rose when, my lord, the charge sheet had been filed. My lord kindly comes to the charge sheet at page 31. At page 31, my lord. My lord, the principal accused person, Bilash Mondol, that is the brother-in-law of the petitioner number 1, who was instrumental in causing all this harm and abuses on the petitioner, my lord, he had been non-charge sheeted. Not only Bilash Mondol, my lord will kindly see the other non-charge sheeted person.
You were
was
informed about the result of the investigation when you
My
were
lord.
informed about the page 33 bottom, page
My lord.
33 bottom.
My lord, I had not been informed. That is my grievance. I
Where
had
have you-
not been informed. My
Where,
lord, kindly
where
see.
have you stated that in your petition?
My lord, I'll come to that. My lord.
চলে আসুন কিছু নেই ওলা
My lord,
নারাজ
My lord, so far the Naraji is concerned, my lord, that
Ah.
I had not even been informed, so I did not have the option to file the Naraji, and
They
the
are say-
police report has,
state is saying you have filed Naraji.
my lord, Naraji had not been filed, my lord. Subsequently, when I went to file the Naraji petition, it had not even been taken on
Page number.
record. That is my grievance, my lord.
What happened? That is
When I went to file the Naraji petition was refused at the outset. It had not even been taken on record, my lord. And my lord will kindly see the kind of investigation that has been done. The charge sheet has been submitted wherein Bilas Mondal and his wife had non-charge sheeted based on the
You've got
fact
a report.
that the investigating.
No, the report includes the ad you inform the complainant, the outcome of the investigation. Huh? চলে আসুন ওটা প্রিজুম করে নিয়ে অর্ডার করে দিচ্ছি ফেলে রেখে লাভ নেই the
Well,
petitioner
kindly see is what.
this will go I'm directing the magistrate to consider your application under 173(8). Petitioner alleged is
The
that
case has already been committed. Case
committed
has already
what?
been committed.
So now
the-
what is the spirit of 193 now? That even at the
Lordship.
trial you can file for further investigation.
My lord, kindly direct the trial court to entertain my petition.
Petitioner complains that the principal accused, according to her, has been left out when the charge sheet was submitted by the investigating agency, and the petitioner was never informed regarding the outcome of the investigation. Full stop. The petitioner approached the learned aid magistrate / trial court with a prayer for further investigation under section 173(8) of the CRPC, but the same was not entertained by the concerned court. Full stop. Learned aid court in of এটা তলপটি ঘাট PAL
Talpati Ghat Police Station.
Talpati Ghat Coastal PS case number 11111 of 2023. Learned court. Be the learned magistrate or the sessions court would assess whether any notice was served upon the de facto complainant. In case no notice has been served, de facto complainant should be granted permission to file the application under section 173(8) of the Code of Criminal Procedure. Learned magistrate will consider the same on merits and thereafter dispose it of in accordance with law. Full stop. If the petitioner approaches the jurisdictional court insisting of the aforesaid case within a period of 15 days, the learned aid court would, yes. That is a format statement given. That's why I've said the court will check that. That's written.
My lord, kindly appreciates the finding. The person who has been non-charge treated was non-charge treated on the basis that he was in hospital, wherein the hospital authority is informing that he was never in the hospital.
These are revisional applications. These are not 226 matters. You are forcefully making these 226 matters.
I have no other place to go, my lord.
These are criminal revisional application. We'll take steps so that within a month from filing of the application, within a month from filing of the application under section 173(8) of the CRPC, the same is disposed of. They have not entertained, they are saying.
The application is refused, my lord.
Where is the order sheet of?
Passed by the learned court.
How can that be,
Application
sir?
was not even
Order must be
taken.
recorded,
prima facie.
kept with the record. So that means it's not entertained. We've got to need with the aforesaid observations, WPA 4616 of 2025 is disposed of. Needless to state that no affidavit shall be used. Evidence are called for. The accusations made in the writ petitions are deemed not to have been admitted. Reports are submitted, be kept with the record, server copies. Next.
I'm grateful.
What happened, sir? None of you are appearing once the matter is. No, one thing is that so far, why have I kept that? There was I have not allowed anybody to do around Jadavpur University. That is the only reason I have kept. So ask them to come, I'll pass it. হ্যাঁ আসবে আর এত ম্যাটার আছে আসবে না হয় না
আরে কেন 34 নম্বর আইটেম হচ্ছে আমাদের 17
Then I can, I'm leaving it to, so thereafter the administration who will decide? Somebody has got to decide. Court will not take the matter on its own, sir. চলে আসুন তাহলে ডিসপোজ অফ। আচ্ছা, এই তো ওই যে মহিকের জুনিয়রটা আছে, ওটাকে দেখো তো। নো, come. Why are you not appearing item number 2 anymore? You don't have any responsibility once the matter, your purpose is served.
Lordship, I actually apologize. I was in court 15, Your Lordship.
So you have 3-4 lawyers over here. You will be affected by the subsequent orders. That's why I kept the matter pending. Where are your seniors? Enjoying money or what?
Lordship, actually, Mr. Mukherjee had indicated yesterday that he would not be there.
And Mr. Mojumdar?
That is also engaged in the matter, Your Lordship.
So none appears for the petitioner.
Lordship, I am appearing, Your Lordship, kindly. Lordship.
Achalane advocate for the petitioner and state is present. There are no adverse reports. In view of the earlier observation of the court, in view of the earlier observation of the court that no organizations would be allowed, or no political organization would be allowed to conduct any program without the leave of the court till 13th of March 2025 is hereby recalled. Any organization and so willing will approach the administrative authorities, and the administrative authorities at the earliest will dispose of the said application in accordance with law. Sure. Earlier date also you have not given his name. Yes, sir. With the aforesaid observations, only for this particular part I have kept this matter. Because this is not fair that court will keep the administration in its own hand. Administration will have to go on its own manner, sir. With the aforesaid observations, WPA 5. No. With the aforesaid observation, WPA 5326 of 2025 is disposed of, sir. হ্যাঁ, ডিসপোজ হওয়ার কিছু নেই, ওইটুকু খালি রিকল করার ছিল আমার, কিছু না।
বলছি item 8.
Your Lordship, I am appearing on behalf of the petitioner. The petitioner is a 76-year-old senior citizen, Your Lordship, and he was driven out from his house by his son and daughter-in-law, who are private respondent number.
Yes, what is the
516.
report? State. I'll charge sheet now. Is he staying outside?
For the last 1 year, he has been staying at his.
Land is other son fighting. No, other sons and daughters not bothered. So why is the petitioner is one before me?
No, Your Lordship. Their false mutation is all. They have not served any copy, Your Lordship. Lecture P1, whatever it may be, the mutation is standing in his name and he is the owner of the house. Page 13. And they have assaulted the senior citizen.
My lord, after getting the complaint from the petition, I have lodged the FIR against the private respondent, my lord.
Page 20,
Where-
Your Lordship.
Maintenance of welfare and senior citizens, your file, where is that?
Page 28, Your Lordship.
20.
They have been
28.
harassing 28, Your Lordship. It was registered on.
20 is the officer in charge. But where SDPO, where have you filed? The SDO,
Yes, one.
where have you filed?
Yes, Your Lordship.
Where, when is the date fixed?
No date. Just a letter was sent to Your Lordship.
This is
on
to the
8th of-
SP. Why SP is not the authority? SP is not the authority.
They have sent one, SP is district magistrate.
So where is that?
25, Your Lordship.
পঁচিশে কি ठीक है, whatever it is, you are a son also.
Yes.
Then from here I will ask to give maintenance.
He's
Very
staying
good.
at
Say in that tone, sir. Madam,
Yes.
what is the outcome of this?
Your Lordship, they have called the complainant from Hooghly to Howrah, but they have not intimated about his possession of the house, or he was not.
No,
taken
there
to
must
the
be
house.
there must be a number over here.
Your Lordship, this number is.
Where is the number of the
27. Page 27, Your Lordship.
these are 27 is a FIR.
Yes.
I didn't know, Baba. What I am wanting is this. You have this is DM, you have made a prayer
Yes.
under the Maintenance of Welfare of Parents and Senior Citizens Act.
Yes.
So there will be a proceeding.
They have not initiated it yet.
There will be a number and a proceeding.
No, Your Lordship, they have just.
You call for a
received-
report, madam, from the DM office, whether there has been any proceeding or not. For orders, I am keeping the matter. Let the report. There must be a proceeding. You are not participating in that.
They might have sent the intimation to his house and he's staying with his friend at
So
Hooghly.
whatever
Your
it is,
Lordship.
let them inform at least the
Let them
number,
inform.
because you have approached the appropriate authority who is supposed to pass the order.
Yes, yes, Your Lordship.
This court, as a writ court, can only pass certain flimsy
Maybe
orders. So
Stay at his home, Your Lordship. He
that
is,
if that order is already passed,
Your Lordship. I may be intimated.
Mm.
These things comes at a later.
these are all issues, sir.
facts.
Even if a father has no property or is
Deprived of his
the
home,
father,
Your Lordship, this affidavit
Huh?
of service.
that is a secondary issue. You submit a report from the district magistrate and collector in respect of the communication dated 18/3/2024, page 25 of the writ petition. Petitioner, being the father, is aggrieved by the actions of the private respondent in numbers 5 and 6. State has submitted a report, but the writ petition encloses a document wherein a prayer was advanced to the district magistrate. আমার এটা কোথায় গেল? পোস্টিটটা কোথায় গেল এখানে বলতো? এখানে পোস্টিট নেই কেন? একটা ফ্ল্যাগ করে দিত। ও ওইখানটা।
They have assaulted him severely, Your Lordship, and the medical report is also enclosed.
Before the district magistrate and collector বলেছি? District magistrate and collector, Howrah. Full stop. Learned advocate for the state would submit a report in respect of such information of the representation dated 18/3/2024 with prayers made by the petitioner under the relevant provisions of the Maintenance and Welfare of Parents and Senior Citizens Act 2007. Let such report be submitted. কবে দেবো আর আজ কত 12 তারিখ, 2 সপ্তাহ তো দিতেই হবে। 27 কি বললাম? On 27th of March 2020.
Any day in next week, my lord.
Then let the father go inside, you file your
Yes,
opposition.
Yes, Your Lordship. Let him
Adamancy, I don't
intimate
tolerate in court.
at his home and they may
Highly obliged, my lord.
deeply obliged.
File the report, thereafter I decide. Today I am not deciding. The reports are submitted, be kept with the record. Dispose no hai. 27th under the heading for orders. ও হয়ে গেল বাস, আজ সারাদিনের কাজ চল এসব। Just 1 minute, please wait. There's a fixed matter at 11:30. Let me dispose it of.
11:30 fixed matter 119.
At the time of mentioning of this matter, I informed your lordship that the issue involved is in this petition that the police, I have cooperated in following 35 notice. I was examined by the police 1.5 hours. I was and then another officer asked me to hand over my mobile, that I refused. So they have made an endorsement, non-cooperation.
the very next thing, they have served me with another notice under section 35 only, saying that you bring your identity card and mobile. I have two-fold of submission. One is based on Article 20 subclause 3, that principle of self-incrimination, that you cannot force me. Second, that even during the Supreme Court says consistently, even during interrogation, I may keep my mouth shut if I feel that my information may implicate me in any case. Now, Supreme Court is considering this matter. A bunch of writ petition under Article 32. Supreme Court has passed at least 3 orders in 2022, in 2023, and 2024. Restraining the authorities to ask for any digital device. This is the orders that I will be praying for to decide the issue. To decide the issue, they may use affidavit. For the timing, I am praying for the similar orders passed by the Supreme Court.
Matter can be, I think the matter can be disposed of within 5 minutes. If you also allow me, but other can say 5 minutes, can you also allow me 5 minutes?
I have taken 2 minutes.
Number of, yes, maybe 2 minutes. Number of whatever judgment they were, those judgment, my lord, naturally, my lord, after the promulgation of the new act. The lordship kindly have a look. I know that my lord much bigger than me. That my lord, the earlier section was, my lord knows that 91. Now the language of earlier section of 91 and the present section was the corresponding my lord 94. The lordship kindly see first my lord section 94.
There is no interim order, exchange of evidence.
No, may I tell one thing?
I'm not taking
Just kindly allow me, my lord, can
exchange of evidence come up with
allow me, my lord.
you can you no inter investigation koi interim order hobe kichu na exchange of evidence you will investigate. I am not passing any order
because 94 says that if
let him place us
and all those judgments are violated.
and it's not a blanket right to silence. There is a provision under which you can
balance, yes.
So you come up with your affidavits, proceed with the investigation in whatever.
No,
obviously stay there was ki
so mobile is concerned that but Supreme Court has said that.
So
kindly see the one order of Supreme Court once. Order of Supreme Court.
Supreme Court ki boleche dekhi.
At first 2022. No. Even 2024. Now this is not.
Yes, what? First come. What he said. In the meantime, there shall be stay of the this is a ratio.
This in the issue involved in this petition. In this
whatever it is, sir, then that is to be decided. You see over here, you are working.
3 orders.
You come to this one. This is issue notice. In the meantime, there shall be stay of operation of the content in the emails. There is so and so. How this is
and the rest part.
So this is order in the circumstances of that case, sir.
Every case is the only issues involved. I have pleaded that whether I am bound to hand over my personal device because personal device contains my personal data, my passwords, etc., my photos. Whether I am bound to no 94 notice has been issued. They have issued a 35 notice. 2024 order, can you see?
These are all interim orders.
Interim order, I am seeking also interim order. Can you see 2024 order? 2024 order, 2024 order, Supreme Court courts every prayer and then pass an order. Order dated 2024 on 13th December 2024. 13th December 2024.
You tell me one thing. What is the order over here?
13th December 2024.
Which one?
13th December 2024. SLP millet.
No, 24 decision.
515 SLP millet.
One is 9th of December, another is 7th of November, another is 9th of December you have given. Same order, I believe.
All orders were similar, all in this bunch of writ petition under Article 32, and Supreme Court is restraining them to have not access on my personal device. My personal device contains my personal data. Why shall I disclose it?
Because
I don't have trust on police. Let there be a court order then only. Section 35, they have issued notice under section 35. They have not issued not any other notice under section 94 or 91. 35 notice does not mean
But there are so many judgments.
Expiry order, if you want to change it.
That judgment order today itself.
अच्छा ठीक है सर.
The nomenclature.
Directly this one not to
scope of 226 226 broader than what 32. But this is all about fundamental rights. All about fundamental rights. If there is a law and order situation and if they have some
Sir, interim order has got no binding, sir.
interim order was granted by the Supreme Court.
That means I will bound. I'm bound by an interim order.
All that I'm saying, Milad, but kindly consider that. Before passing,
I can take the spirit of the order, everything like, but I am not bound by an interim.
I don't say unless it is a precedent.
So when this new act was not over.
But I don't say unless it is a precedent. But I don't say that.
This act has come in.
But may I make this submission?
And
what is here? Yes.
Let kindly take some lead. The constitution. Constitution. In absence of constitution, may I make this submission? That Supreme Court, the issue before the Supreme Court is that whether my right, the police can violate my right to privacy. The right to privacy is that when I am having a mobile or any laptop or any other electronic device, that this contains my passwords of the bank.
Sir, one thing, all these rights are subject to criminal cases being registered. It starts from 1997. Even phone tapping was allowed if a criminal case is there.
In this, I mean, 2 minutes. Right. Now, before Supreme Court, the issue is whether they can, in a criminal proceedings, there are cases are registered by ED, where financial frauds are being done, and other criminal cases. But police was issuing notice for seizure of on the basis of court order. Even in our case, there is no court order. Issuing notice for seizure of this electronic device. That was the issue before the Supreme Court. Now, Supreme Court says that this issue needs to be decided. And Supreme Court directed by the Union government to frame a guideline. In which cases, as it has fallen from your lordship, in some cases, the investigating authority may be requiring my device because they have information, credible information that this device has been used for certain criminal offense. There may be. Then you cannot, there cannot be a blanket.
So either you go, sir, let them come up with their affidavits.
Now, in my, if they come up with my affidavit, today, they will have my mobile access, they will access my mobile. They may seize my mobile. I am a student. Every day I use my mobile. But there correspondences from the university are communicated through WhatsApp. There are WhatsApp group of my teachers. But these are my private communications. Why shall I? Particularly in a case where police is acting bias, I am saying. And the cases are pending where the FIR has sought to be quashed. That prayer has been made at least.
From now onwards, you are wanting interference.
No. All that I am saying,
source of power. The only question is source.
Now,
one thing only I will ask.
How they have this?
Have you served a notice, a summons under section 94?
No.
94 has not been served, but my lord, still I can say before your lordship, my lord, only the one paragraph. Lordship, kindly have a look.
That's my point. They cannot do under section 35.
One 49. This is my lord the.
And how can they record this non-cooperation? After examining me after 1.5 hours?
This is my lord the judgment was reported in 2022 KSCC 700. Only one paragraph number 149. She kindly have a look. What I am trying to do, my lord, establish that yes, my stand is correct. But if there is one principle more well settled than any other, it is that when an authority takes action which is within its competence, it cannot be held to be invalid merely because it purports to be made under a wrong provision. If it can be shown to be within its power under any other provision, a mere wrong description of the source of power, a mere wrong level, cannot invalidate the action of an authority if it is otherwise within its power. It is with my power, within my power. Now, Lordship, thus, as long as a source of power to legislate or issue a notification is available, the lack of mentioning an incorrect reference or mistake does not vitiate the exercise of such power. I am on this point.
Nobody is disputing
some
this
mistake that
this
can
principle.
be issued instead of the leveling 94. But that does not mean that you would not, my lord, respond to that.
So this is different. I do not know the genesis of Titagore paper mills case, but when it affects the rights of liberty of a person, you have got to strictly adhere to the law. For example, I am saying you issue a notice as a witness. It's very difficult for the court to interfere at certain stages, but we don't approve of certain circumstances. You call a person as a witness, you arrest him thereafter. You have power both to issue notice to a witness and also to an accused.
And the government is not that it is under 35(3) but not under section 94. The contention as it appears from the amendments made in the petition is that would infringe my personal liberty.
No.
But kindly consider
this is not, sir, that I agree with you.
May I tell one? The notice has been served. Apart from the level of the notice, the long description of the power mentioned therein, but it has been by not it is settled that he has understood the purpose and issuance of the notice.
Where is that 35(3) notice?
At page 50.
Page 50? 50 is an order.
56.
56.
56.
Oh, second 56.
56.
Yep. Page 56, first paragraph, first last line. And non-cooperation at
If there is non-cooperation, fact is that
Non-cooperation, I am not. But where have you wanted that mobile device over here?
First
In this
paragraph, last
contents of 35.
First paragraph, last line.
first paragraph.
ID proof and mobile phone.
You are directed to appear before me with ID proof and your mobile phone.
ঠিকই আছে তাহলে তো।
You are directed to appear with your ID proof and mobile.
And may I kindly see the provision of 1994? 94, if you are requiring any electronic device, they have to apply before the court. Court has to apply his mind, and then only or written order. There must be a written order. Kindly see the provision of 1994. They are avoiding the provisions. They themselves said that this is a misquotation.
Where is the court involved, or the officer in charge of a police station, or you see
by written order?
There's this is disjunctive. Both the authorities have been given power.
But they have to justify then. They have to write a letter, write an order. That pass an order.
Which is not there.
The authority has to pass an order. Order must be, there must be some justification.
No, that justification is not to be. He said he has wanted the mobile from you. You can give it. You refuse to give it. Adverse inference will be drawn, sir. Even you try to appreciate in Nandini Satpathi's case. Right to keep silence was genesis of the concept flowed from there. You will see it's the power is vested with the police authority is you cannot force, but you can initiate a criminal proceedings.
I don't mind. I don't mind. Let them. But Milad,
That is for them to, that is for them. You have not come for that order from me.
but what of my prayer is, Milad?
No,
Milad, kindly see Milad.
no, in nascent stage, no interference.
There must be some reason. What? There must be some reason that
This is in course of investigation.
in 35, in section 35, there is the provision is very clear. Is there any scope for the police that they have themselves admitted that this is a misquotation of the Milad section that they have said Milad in the open court?
Sir, they can.
Let them have one stand. They are saying this is a misquotation.
No, this is not a revision. I will not see. I will see like this. They could have not quoted any section and wanted from me. I will see it like that.
Fine.
My source of power, and it is there.
Come at a later stage, not at this nascent stage. I don't want to interfere in investigation, sir.
Milad, the investigation Milad, kindly visualize Milad. This is a case of a student.
No,
Milad, every day they uses this mobile. They have their WhatsApp. They access their WhatsApp. The communication from the university. There is a group of the lecturers and the students.
Yes.
What the communications are made. Why shall I, Milad?
Exactly that we want.
You are an FIR named accused. You are an FIR named accused, sir.
No, I am not.
Yes, you are an FIR named accused. Yes, I have seen that. You are Uddipan Kundu or something like that.
Uddipan.
Page 42. You are FIR named accused.
But I am an FIR. Your Lordship has seen how the FIR was made.
I will not go into that at this.
Milad, your Lordship ultimately will go into that. Now, Milad, if
Not now. No.
all my materials.
My appeal court is who you know now. Have you seen the determination?
But that's then I'll be in difficulty, Milad. But
Sir, I have said no interim order, go for affidavits. It's good. You decide, we'll decide the law after saying, in a cool moment, we'll decide the law. Let them carry on with the investigation.
let me carry on, Milad.
Whatever decision you take, court will not interfere over here because you are an FIR named accused. I cannot. One example will set a bad precedent to other accused persons also. আচ্ছা চলে আসুন পড়ে থাক মামলা এখন আচ্ছা
kindly fixes the date, Milad. Oh,
exchange of affidavit কি হবে তারপর কি হবে আমি জানি
that was the thing that I was apprehending Milad, few months back that there may be change and Milad will be in trouble.
না আচ্ছা in view of the
non-cooperation part, Milad, there was no direction Milad, to hand over mobile on the first.
Sir, non-cooperation will be a consideration at this time of anticipatory bail at this stage. Non-cooperation has got nothing to do. Sir, one thing I'm telling you, it's a settled proposition of law. If a person doesn't open his mouth or doesn't answer according to what the investigating officer wants, that is not non-cooperation.
Right.
But these are findings to be recorded after hearing both the sides. Summarily, as an interim measure, I cannot do this.
This is not such a case.
They will take advantage of this issue.
All investigating officers say non-cooperation, sir. Chalo.
We should not take credence of their.
No, I am not saying the issues which you have canvassed, that can be decided, but no interim order. Sir, let them you are FIR named accused. I am this was saying in a page you have page 42. I understand, but you can't agitate and claim sympathy, sir. Yes, there are certain hazards in life in all professions. You are a lawyer, you have got a hazard in life. I am a judge, I have got a hazard in life.
Which is not adversarial.
No. Not in this case. Sir, in other cases I consider, in this case I will not consider.
But so far, if name is accused is concerned, this is my suggestion. Let them clone the phone and hand it over to me.
That's a 1 minute job. You tell me. Cloning the phone is 1 minute job. They have got to go to SDF building and all this.
Let them 2 days. I cannot purchase another.
You go to the learned magistrate. That Mr. Sen will see how many days it will take at a limited so that he is not forced to purchase any. No, no, you will keep everything. I'm not saying you keep it, but don't force him to purchase another mobile. Up to that.
Kindly road on record.
No, no, I have told him he will see. You you retrieve all the materials, whatever you require, retrieve everything. But the supervisor said is chalo. State is directed to file its affidavit. আচ্ছা একটু এক লাইনে in the view of the issues canvassed in the present writ petition, state is directed to file their affidavit in opposition in respect of the contentions advanced, preferably by একটু টাইম দিয়ে দিই এখন চলবে তো ইনভেস্টিগেশন চলবে তো এরা তো করবে না কবে কত 4th of April আর একটু বেশি or 11th of April 4th of April 4th you are comfortable by 4th of April 2025 আর এই you 1 week এটা ভালো হিয়ারিং করে দেবো যদি থাকি না না some other court will come up. এদের কিছু নেই এই মামলাটা হবে ভাই নাহলে আমি ইন্টারফেয়ার করে যাই আমার কোনো ইন্টারফারেন্সের জায়গা নেই affidavit in sir there are holidays, don't do early because no court. If I say 11th, from 12 to 15 days holiday, only 2 working days in that week, so you take time, file by 21st. If you can just shift up to 10th of April this because midweek
I can use it even if I out of station.
no I'm not asking you to do the matter exchange of affidavit so 4th 21st করে দাও affidavit in reply be filed by 21st of April 2025 or after exchange of affidavit it's we list the writ petition under the heading hearing না hearing orders are পেরে উঠছি না on the last week of April 2025 ব্যাস এই পর্যন্ত থাক তারপর যখন হবে তখন দেখবো কতটা ইনভেস্টিগেশন প্রোগ্রেস হলো আমার বই গো এইটা দিয়ে দিন এটা ওরা আসুক তার আগে আনন্দীকে ডাকা আমি ঘুরে আসি তাহলে 5 minutes I am taking this এই তো 5 মিনিট বলে তো এই তো নিয়ে নিল হ্যাঁ বলেছি আর কি করছেন লোক হ্যাঁ কোথায় আনন্দী কোথায় 5 minutes Yes, Mr. Mr. Dotto, I'm giving my mind to you. You rebut. That will be better for me to understand why I should not pass an order.
Right.
You start from there. I'm just giving out my mind why I should not pass an order.
Yes. 5 quick paragraphs of the writ petition. Please take paragraph number 11.
Yes.
Paragraph number 11. Without any provocation and without any opportunity to the petitioners even speak to the police officers, the police personnel came down heavily upon the petitioners, and the 4 other protesters started assaulting them with lathis, fists, blows, and boots, and owing to severity of the assault, the petitioners suffered grave injuries, and the petitioners, namely so and so, became unconscious. Why I am showing this? Because this is, Millard, at the point of agitation, not in the police station. This is very important. I go by the case made out in the writ petition. Then please take, Millard, paragraph 18.
After 11:18.
11:18. I'm sorry, 15, sorry. Then, Millard, they are taken to the police station. In 15, Millard, they say, Millard, what has happened in the police station. Please have a look to that.
The petitioners in the statement identifying herself as officer in charge of the local police station with 4 other lady officers. And the woman police station started beating and assaulting the petitioner all over their bodies while hurling abusive and filthy language. The in charge took out her belt and used it as a whip. Petitions. Yes.
Then please take, Millard, paragraph number 18. This is again in the police station. 2 police officers allegedly, Millard, stood on the leg of the petitioner number 1 and beat her with a cane.
Yes.
Then kindly take me paragraph 22. Second sentence. While the petitioner number 1 tried to write her name, hot melted wax from a burning candle was poured into her hands, for which she sustained several burns. Please mark this. Then paragraph 23, beating, became senseless. After she regained her senses, she found herself in the officer in charge's room. Then please take, Millard, paragraph number 25. The third sentence, 4th line.
20, I'm sorry.
25.
25.
4th line. Both Ranusri and Bodnalia were asked to beat each other. When they refused, they were again brutally assaulted. Hot melted wax, a burning candle was also poured into the hands of so-and-so, especially at her fingers. Next is, Millard, paragraph 29. Yesterday, if your lordship kindly recollects, I said that Suchodita was also there. My learned friend had disputed. Please look at para 29. Suchodita means, Millard, the other writ petition, which was moved yesterday.
Yes, sir.
Then please take what is very, very important. Para 31. The local political leaders were there. Para 31, Bhavani Chakraborty, a local committee member. Your petitioner came to visit the petitioner sometimes in the afternoon at the police station, and then the petitioners, one after the other, were taken out from the lockup to the room of the officer in charge. Then, Millard, they could not walk properly, etc. Then take Millard, para 32. Again, while the petitioner entered into the room of so and so, Bhavani Chakraborty, her wearing apparel were in torn condition due to torture inflicted upon such and such. So entering with a leader in the OC's room. Then please take, my lord, the allegations of, then please take my para 39. Suddenly, at about 2 a.m. in the night on 4th March, the petitioners were made to wake up and were taken to the room of OC where they were asked to sign on so and so. Petitioners signed under fear and compulsion. So and so asked to leave. On being asked, where would they go in the middle of the night? The officer in charge replied that it was not her concern. Fortunately, the petitioners found their senior party members waiting at the police station, and the petitioners ultimately left the police station and headed for their respective homes. So, my lord, the political leaders, as per the statement, were there, my lord, during the in the afternoon, and at the time, my lord, when they were released in the early morning. Now, paragraph 41.
When from what your records show, when from they were detained?
My lord, they were detained from around, I think, 12 noon. Exact time. 10:40. 10:40. Around 11. From 11 onwards. Or 10:40 onwards. Let us be specific. 10:40, they were taken to the police station. Middle of the day, my lord, the political leader was there.
So basically from 10:40 a.m. to
2 a.m. on the next day.
AM is
of
3rd March. And 2 AM is of 4th March.
So, my lord, the pleading is Bhavani Chakraborty was in the police station, who went with them to the OC's room. And when they were released around 2 in the morning, Bhavani Chakraborty and other leaders, not he alone, were there, who had escorted them to their respective houses. Now, kindly take, my lord, paragraph number 38 on the tribal allegation part. My lord, I'll, my lord, dissect my argument into 3 parts. One is, my lord, whether, my lord, a believable case has been made out for, my lord, the public law remedy to be availed for compensation.
So that is a final one.
No.
You are now,
Prima facie, they have to make out a case.
to
Definitely.
Maintainability of the writ petition
Yes.
is
Second is the maintainability of the writ petition.
believability.
Or I put, my lord, the maintainability as the first one.
First one.
Yes.
That is,
That is more important. That is more important. Very well. Maintainability is my first point. Availing the public law remedy is my second point. And third point is applicability of the SC/ST Act.
Two things I have got. Are you ready with the records of the case, sir? 10:40 AM to 2 AM. And do you have records to show how at 2 AM in the night you asked a lady or a girl to leave the police station? Do you have any records to show in what manner?
Yeah. ডকুমেন্টটা দেখান। My lord, the instructions are after completion of the legal formalities, bail bond executed by one Swarnendu Bikash Shashmal, son of Bhupendranath Shashmal of so and so place, Kotwali.
Why did you detain them up to 2 AM in the night, sir? They are ladies after all, sir. Why? You could have, I understand the tension was there. You could have left them at 7 or 8 p.m., something like that.
But this was a woman's police station. Yes.
I understand, but then either you decide to produce before a court within 24
Will be
hours.
the preventive detention.
I
that's right,
understand, but
yes.
preventive detention also,
Yes, I get your
in
lordship.
political agitations, we have seen that after a reasonable,
After a reasonable time,
period of, this is not a reasonable period of time.
Yes. But there, my lord, that they could have been, my lord, released before also. My lord, I will not, my lord, make any submission on that. It could have been done. It could have been done.
Yes.
The fact that the other persons were there, my lord, I wanted to show from the
Admissible.
pleadings of their pleadings. Therefore, my lord, it's not a case that one has been picked up, kept over there in isolation. Nobody could know. The family members were not aware. Nobody was aware. Nothing of that sort. They make the pleading that people were there. And when she comes out, she finds that the other leaders were also there. Therefore, my lord, this is the situation. Now comes, my lord, the tribal community part. Please take paragraph 38. Petitioner number 1 was humiliated, ridiculed, and scorned for hailing from a tribal community and was severely humiliated over her caste and the tribe in the filthiest manner, etc. Then, my lord, the usual allegations of, my lord, complaint being refused. These are paragraphs 41, 44, and 45, which relates to my first point.
44.
41,
Oh, 41.
44, and 45. But these are, my lord, usual paragraphs that went to the police did not accept the complaint, etc. Then comes, my lord, the hospital's refusal, which is 42 and 43. 42, my lord, I lay emphasis. Suffering from the pain, injuries, etc., went to the emergency ward. However, soon narrated the incident of torture inflicted upon them by the women police station. The doctors of Medinipur Medical College refused treatment and refused to provide any report of their injuries being inflicted by the police, and simply issued a prescription stating physical assault as the cause of injuries and deliberately, kindly mark this part, deliberately not indicating the names of the police officers who inflicted such injuries. Then comes, my lord, para 43. Denied of the basic medical treatment, were thus compelled to come to Kolkata, visit medical college for treatment. Similarly, at the medical college at Calcutta, attending doctors refused to provide any report of the injuries being infected by such and such. These are, my lord, the pleadings. Kindly accept these to be correct for the time being. Because I have not used an affidavit as of now, I'll use it, my lord, at the appropriate time. Now kindly look into the medical reports. I have shown to your lordship yesterday, but please have a relook to it in the backdrop of the allegations that, my lord, I have placed. First, my lord, pages 34, 35, 37, and 39. All physical assault, Brufen and Pan 40. Paragraph 42 and 43 says that medical college in Midnapur denied medical treatment. Therefore, they came to Calcutta. Very well. Now, kindly see the Calcutta reports. First is page 41, P2. Petition number 2. Again, kindly see the advice is ibuprofen, pan 40. Page 42 is petitioner number 4. Same thing, ibuprofen, pan 40. Then kindly take page number 43. This is petitioner number 3, ibuprofen, pan 40. Petitioner number 1, I do not know whether she had come to the Calcutta Medical College or not. Her prescription is not here, subject to correction. What is most important is no burn injuries.
That's a petitioner number 1 only.
Yes.
There is no petition number 1's medical.
Medical from Calcutta.
Calcutta.
Now kindly
what
take.
was disturbing me, one thing, just explain. This is the representation or this is the recording?
Milord, your lordship is referring to Milord page?
Page 41.
Page 41, Milord, is Milord what has been represented to the doctor by the patients.
No, but then there is a heavy blunt injury.
Yes. With
over
kick,
left
belt
elbow
and
region.
sticks. Place of incident, they say, is Patna Bazar.
No, that I am not. This is after checking the doctor writing, or is because heavy blunt injury.
Yes.
This the person will not say. Physical assault, it's all right. Just in
No, the person says, but otherwise kick, belt and sticks will not come. What is the doctor's opinion is, Miller, at the top
So,
of the left.
how can blunt injury be over here?
Yes.
You see, alleged physical assault, I understand, is the representation made by the patient concerned.
Yes.
Heavy blunt injury in bracket.
Yes.
Over left elbow region, left shoulder region, back region, right hip region. Let us say, now without seeing that, if we accept for the time being, will this investigation be prescribed by the doctor? I'm just asking you.
Can you see the column head? Column head is complaint.
The next one is investigation.
Next one, investigation means investigation by the doctor. Not investigation by the police.
No, that I understand.
Yes.
But this is subject to the left L. I understand that some of the parts the doctor may not have checked. But this left elbow region, left shoulder, left shoulder also.
Yes.
Let's stick to left elbow region only.
Very well.
These are physically available, which a lady can show to a doctor concerned without changing anything. Now, is it that the doctor, without checking, advice for X-ray?
Milord, the doctor, possibly, Milord, when doctor advises X-ray or any investigation, Milord, it is to be presumed that the doctor has looked the patient, seen the patient, considered with the whatever injuries or the wounds are there, and Milord have advised X-ray. This is the normal presumption.
And what are these two? One, the bottom one, DOI, date of incident.
Date of incident.
MOI?
Mode of injury. Mode of injury, then place of injury. Whatever is, Milord, in the left-hand side column is what has been represented before the doctor. Then the investigations, Milord, directed are X-rays, and on the right-hand side are, Milord, the
so whatever medicines.
Medicines. এই নর্মাল রিপোর্ট কোথায় পাচ্ছ? না কোথায় নর্মালটা কোথায় পাচ্ছ? ও আচ্ছা 44 Miller, there is an X-ray report which says no bone injury is found. Adjacent soft tissue shadow appears normal. Anyway, we are not, Miller, on those parts. Now please come, Miller, to Miller page number 46. This is the complaint. But the lawyer has found that all senior leaders were there. during the detention, post-detention, waiting to receive them outside the police station. Now the complaint is lodged, my lord, after a gap of maybe 72 hours or somewhere around. And in between, where I am told to, my lord, your lordship may note it, that on the 5th of March 2025, a press meet was organized by them. That is not stated, but I am been prompted to say 5th is a press meet, 6th is, my lord, the complaint. Now kindly see, my lord, the first paragraph at page 46. এত দ্বারা আপনাদের জানাইতেছি যে গত 3রা মার্চ যাদবপুর বিশ্ববিদ্যালয়ে পুলিশ এবং তৃণমূল আশ্রিত দুষ্কৃতী তাণ্ডবের বিরুদ্ধে আমাদের ঘোষিত কর্মসূচি অনুযায়ী বিদ্যাসাগর বিশ্ববিদ্যালয়ের গেটের সামনে শান্তিপূর্ণ কর্মসূচি চলছিল। এই কর্মসূচিতে বিদ্যাসাগর বিশ্ববিদ্যালয়ের সামনে অতর্কিতভাবে পুলিশ আমাদের উপরে চড়াও হয়। দিস ইজ মিলার আউটসাইড দি পুলিশ স্টেশন। এবং টেনে হিচড়ে গাড়িতে তোলে এবং গাড়িতে ক্রমাগত আমাদের বুট দিয়ে লাথি মারতে থাকে। এই সময় আমাদের সাথী সোয়েন্সো ঘাড়ে সজোরে আঘাত করে, ফলে সে সংজ্ঞাহীন হয়ে পড়ে। বহুবার চিৎকার করে জল চাওয়া সত্ত্বেও জল পাওয়া যায়নি। আমাদের টেনে হিচড়ে গাড়িতে তোলার সময় বহু পুলিশ কর্মী আমাদের গায়ে হাত দেয়, এমনকি সোয়েন্সো পর্যন্ত হাত দেয়, জামা কাপড় ছিঁড়ে দেয়। This entirety of this allegation is not, my lord, in the judicial pleadings which I have read. These are, my lord, embellishments which are coming later on. Then, my lord, Chulen Muti and etc. my lord, I skip over. Then kindly take page 47, the first paragraph. একজনকে রেখে বাকি 3জনকে লকআপে নিয়ে যায়। নিয়ে যাওয়ার সময় অশালীন কথা বলতে থাকে। এসআই লীনা মাহাতো, নেম the surname is very important. লীনা মাহাতো আমার জাত নিয়ে কুরুচিকর মন্তব্য করে বলে, সোয়েন্সো নিচু জাত, তোকে এত সাহস দেয় কে, ছোট জাত, ছোট লোকের মতো থাকবি। This is on the third aspect which I want to address your lordship. Rest, my lord, I don't think is very important. Then therefore, my lord, the case is that first at the spot or where the agitation was going on, some police atrocities had happened. The second case is that in the police station, XYZ has happened. The result of XYZ in the police station is not apparent from the medical reports which they have filed. The third aspect of the matter is non-cooperation by the Midnapur hospital is not established prima facie because, my lord, there is no variance between the medical reports of Midnapur College as well as Calcutta Medical College. There is no variance. Only to make out a case where a second, my lord, medical treatment is made, and that too 6:52 in the evening. And, my lord, a stray comment about, my lord, the SC/ST Act. But these are, my lord, the basic facets of, my lord, this petition. Now kindly see, my lord, what is the legal position. First is, kindly have a look to, my lord, Alec Padamsi, my lord, there are a host of cases. I will not burden your lordship, my lord, with a number of cases.
No, burden me. I'm ready for that today.
No, it's a well-established, my lord. It's just one from our court, one from, my lord, the Supreme Court. Please take, my lord, 2007, volume 6, Supreme Court cases 171. Please take the first paragraph, why they are before the Supreme Court in an Article 32 petition.
Remember, this was placed in Rizwanur's case.
Yes.
Justice Datta did not.
Yes. Exceptional.
Yes.
These petitions are filed under Article 32 of the Constitution. The petitioner stated that they have approached this court because of inaction of the official respondents in not acting on the report lodged by the two persons, namely so and so. The basic grievance is that though commission of offences punishable under the IPC was disclosed, the police officials did not register the FIR. So this is the background of the case. Now, my lord, I skip over paragraphs 2, 3, 4, 5. Kindly comes to me that paragraph 6. My lord, in paragraph 6, my lord, Placita F, kindly take. These aspects have been highlighted by this court in All India Institute of Medical Sciences. So and so, it was specifically observed that a writ petition in such cases is not to be entertained. The above position was again highlighted in Gangadhar, Minu Kumari, and Hari Singh. Whenever any information is received by the police about the alleged commission of offence which is cognizable one, there is a duty to register the FIR. There can be no dispute on that score. The only question is whether a writ can be issued to the police authorities to register the same. The basic question is as to what course is to be adopted if the police does not do it. As held in All India Institute of Medical Sciences and reiterated in so and so, the remedy available is as set out above by filing a complaint before the magistrate. Though it was faintly suggested that there was conflict in views in so and so cases, we find that the view taken expressed in Ramesh Kumari's case related to the action required to be taken by the police when any cognizable offence is brought to its notice. In Ramesh Kumari's case, the basic issue did not relate to the methodology to be adopted, which was expressly dealt with in All India, etc. The view expressed in Ramesh Kumari's case was reiterated in Lalon Chaudhuri. The course available, this is what the Supreme Court in this case is holding. The course available when the police does not carry out the statutory requirements under section 154 was directly in issue in All India, Hari Singh and Minu Kumari. The correct position in law, therefore, is that the police officials ought to register the FIR whenever facts brought to their notice show that cognizable offence has been made out. In case the police officials fail to do so, the modalities to be adopted are set out in section 190 and 200 of the code. It appears that in the present case, initially the case was tagged, etc. So and so. Then para 8, the writ petitions are finally disposed of with the following directions. If any person is aggrieved by the inaction of the police in registering the FIR, the modalities under 190 and 200 are to be adopted. It is open to any person aggrieved by the inaction of the police officials to adopt the remedy in terms of the aforesaid provision. Now, these are being followed. But one of the judgments of our High Court, where the coordinate bench had directed registration of an FIR in the writ jurisdiction.
Yes.
Well, the coordinate bench, in a writ petition like this, had directed registration of FIR. That went up to the Honorable Division Bench. Please take me at paragraph 2. You get a copy though, it is reported. Where paragraph 2, the grievance of the respondent petitioner was that the petitioner had lodged a complaint before the SP alleging certain police officers were involved in the firing at the victims, including the petitioner, and no FIR was registered. So many allegations are against the police, that's why I brought this. On the said complaint. Further, the petitioner's case is that a complaint lodged by the petitioner should have been treated as a counter complaint and a separate FIR should have been registered. Then we'll kindly skip over a few lines. Kindly take the last 3 lines of that page. As could be seen from paragraphs 8 and 9 of the impugned order, a positive direction has been issued to the police authorities to register an FIR based on the writ petitioner's complaint forthwith. But that was the direction of the learned single judge. The question would be whether such a positive direction could have been issued by the learned writ court in the absence of any finding that there has been deliberate failure on the part of the police authorities in taking on file a complaint reporting a cognizable offence bearing in mind the decision of the Honorable Supreme Court passed in Lalita Kumari. I skip over, Millard, the submissions of the learned counsel. Then please take, Millard, para 5. Before we examine as to the applicability of the decision, we need to point out that the said decision arose out of the orders pursuant to an order and direction passed by the judicial magistrate under section 156 in one of the cases. Thus, we are of the view that the first question which has to be considered before a writ petition of such a nature is entertained by the learned writ court is as to whether a writ of mandamus is maintainable when the remedy has been provided in the Criminal Procedure Code, more particularly under 156(3). The argument of the learned advocate for the respondent petitioner is that the remedy is not efficacious. We are not persuaded to accept such broad submission stating that in all cases the remedy under 156(3) is ineffective. Admittedly, the power conferred on the judicial magistrate under section 156(3) is wide enough to order an investigation, and the judicial magistrate will be in a better position to appreciate the factual matrix which will be placed before the court to consider as to whether the jurisdiction under section 156(3) of the CRPC requires to be exercised. In our prima facie view, by way of affidavits, it would be very difficult for a writ court to come to a definite conclusion that a positive direction needs to be issued under Article 226 of the Constitution for registration of an FIR. Of course, we are conscious of the fact that there are exceptional circumstances where it has been held that the remedy under 226 of the Constitution is not fully barred. Nevertheless, the court is required to pose a question to the writ petitioner at the first instance as to why the writ petitioner has bypassed the remedy available under 156(3) and resorted to filing a writ petition under Article 226 of the Constitution. In this regard, it is worthwhile to point out the procedure which has been contemplated under Chapter 15 of CRPC from sections 200 to 203, etc. Then kindly skip over 8, 9, and finally, the Honorable Division Bench at paragraph 10 sets aside, the order of the learned single judge.
This is where the FIR was registered.
Was directed to be registered.
FIR was directed to be registered.
Because the allegation over there was like this case that we went to the police has not registered, therefore I have come before the writ court.
Yes, sir.
Therefore, the standards, have been laid down. The procedure has been laid down. What question is to be asked by the court to a writ petitioner who comes before this court with such a prayer has also been laid down. And finally, this paragraph 7, the first part is also quite important, where the Honorable Division Bench says even after exchange of affidavits, it is very difficult for the writ court to come to a conclusion as in regard to registration of an FIR. Therefore, my lord, without multiplying cases, my lord, this is a settled law. And my lord, the division bench takes note of Lalita Kumari and also my lord comes to this. And subject to correction, now that I cannot appear in that matter anymore, then my lord, I appeared for one of the parties. Possibly, my lord, this question has not yet been decided because the matter was relegated back to the learned single judge. Subject to correction, possibly it has not yet been decided. But be that as it may, my lord, this is what
Sufferance of appeal.
we can bring that also before this court. So, my lord, this takes care of, my lord, my first point that, my lord, a writ petition praying for a mandamus to direct the police authorities to register a case is not maintainable because the statutory remedy is available. Point number 1. Point number 2 is, my lord, on the aspect of so-called police atrocities in, my lord, custody. But we often, my lord, refer to, my lord, DK Basu's case. DK Basu has laid down the parameters. But post DK Basu, my lord, there are certain, my lord, what should I say, exceptions or, my lord, certain parameters which were also laid down, which are also required to be considered, my lord, along with DK Basu. In a case like this, petitioners have come before your lordship saying that we have been assaulted, this, that, etc. DK Basu was at an era where, my lord, we did not have all those CCTV coverages. Today, my lord, in fact, my lord, I was discussing with some people. Today, my lord, investigation has become very easy. Because mostly, my lord, places are, my lord, covered by CCTV, at least in urban areas. Rural areas, there is not much coverage, but in the urban areas, my lord, because of, my lord, CCTV coverages, things have become very easy. Now, in the changed situation, my lord, your lordship must consider, my lord, these bold allegations of police atrocities. Now, please take, my lord, the judgment of reported in 2006, volume 3 Supreme Court cases, made a celebrated judgment Subhay Singh, 178, 2006, 3, 178. But please come to, my lord, paragraph 37 instead of, my lord, taking your lordship through all these. In DK Basu, this court again considered exhaustively the question and held that monetary compensation should be awarded for established, my lord, I lay emphasis, established infringement of fundamental rights guaranteed under Article 21. The court held custodial violence, including torture and death in the lockups, strikes a blow at the rule of law, which demands that the powers of executive should not only be derived from law, but also that the same should be limited by law. Custodial violence is a matter of concern. It is aggravated by the fact that it is committed by persons who are supposed to be protectors of citizens. It is committed under the shield of uniform authority, etc. But I don't dilate much on this. This is number 1. Number 2 is para 38. It is thus now well settled that the award of compensation against the state is an appropriate and effective remedy for redressal of an established infringement of fundamental right under 21. But I am conscious of the stage at which, my lord, I am arguing this matter. I am at the prima facie stage. Therefore, my lord, prima facie also, my lord, something has to be established, not to the hilt, but at least, my lord, a believable case or a case or facts inspiring confidence in the court that something has happened, which requires a further scrutiny. Now please take, my lord, paragraph 41. Then Nilabati Behra is considered in para 41. Again, my lord, it says that only in a case of established, my lord, violation. Then para 42, my lord, another part of DK Basu is quoted. Now please come to, my lord, paragraph 45, 46 and 47. These are the last three paragraphs. I'm sorry, 45 also we can skip over. 46. In cases where custodial death or custodial torture or other violation of the rights guaranteed under Article 21 is established, the court may award compensation in a proceeding under Article 32 or 26. However, before awarding compensation, the court will have to pose to itself the following questions. A, whether the violation of Article 21 is patent and incontrovertible. Very, very important. Or in other words, my lord, on the face of it for the petitioner, and for me, it cannot be denied by any circumstances. B, whether the violation is gross and of a magnitude to shock the conscience of the court. C, whether the custodial torture alleged has resulted in death or whether the custodial torture is supported by medical report or visible marks or scars. These are, the high tests in the public law remedy field or disability, where there is no evidence of custodial torture of a person except his own statement, and where such allegation is not supported by any medical report or other corroborative evidence, and where there are clear indications that the allegations are false or exaggerated, fully or in part, the courts may not award compensation as a public law remedy under Article 32 or 226, but relegate the aggrieved party to the traditional remedies by way of appropriate civil criminal action. We are pausing here for a moment, my lord. Please consider, my lord, what the Supreme Court has said, I cannot say, but what I can argue is, my lord, prima facie, without affidavit, calling for affidavits, taking the pleadings and the documents on record on its face value to be correct, whether, my lord, these parameters not to the hilt but prima facie can be said to have been established prima facie at this stage based on the pleadings. What are those? Number one is that the custodial torture is patent for them, or they have made out a case of patent torture. With it, plus, not in the alternative, plus that I am in no position to controvert it. Police is in no way, in no manner in a position to controvert it. So patent from their side, controvertibility or non-controvertibility from my side. These are the first two facets. The second is assuming it has been done. Is it gross or of a magnitude which shocks the conscience of the court? But they tried to make out something, putting below the burned, hot wax, etc. But the medical report does not support. They tried to do that by way of pleadings and in that letter. And Millard, is it, or the third aspect or the third facet is that is it supported by medical reports? One should not, or Millard, the court should not, Millard, proceed only on the basis of the version of the petitioner. But these are, Millard, the high tests. After all, Millard, in the public law remedy, Millard, compensation is prayed for. Once again, at the risk of repetition, I say, Millard, at this stage, they are not supposed to prove it to the hilt. We are at the prima facie stage where, Millard, your lordship, would consider, this is my submission, that whether your lordship will allow this motion to go on threshold stage, because he is not remediless. Whether public law remedy can be availed or invoked in the backdrop of whatever has been put forth before my lord by way of pleadings and evidence as of today. Then kindly take the last paragraph, para 47. We should not, however, be understood as holding that harassment and custodial violence is not serious or worthy of consideration. The Supreme Court is putting the caveat also. Where there is no medical report or visible marks or independent evidence, we are conscious of the fact that harassment or custodial violence cannot always be supported by a medical report or independent evidence or proved by marks or scars. The Supreme Court is also aware of the gross reality that in all cases, it's not possible to establish. After having laid down the law, what the court should pose, or the questions which the court should pose to itself. Every illegal detention, irrespective of its duration, and every custodial violence, irrespective of its degree or magnitude, is outright condemnable and per se actionable. No dispute. Remedy for such violation is available in civil law and criminal law. The public law remedy is additionally available where the conditions mentioned in the earlier paragraphs are satisfied. But there are three judges bench where this has been followed also. We may also note that this court has softened the degree of proof required in criminal prosecution relating to such matters in such and such. When it goes to the criminal prosecution, when we are not at the prosecution stage, therefore, my lord, I will not trouble you. But, my lord, kindly take me the quoted second paragraph. Quoted second paragraph, which is Placida, between Placida E and F, in that page. The exaggerated adherence to and insistence upon the establishment of proof beyond reasonable doubt by the prosecution, ignoring the ground realities, the fact situation, and the peculiar circumstance of a given case, often results in miscarriage of justice and makes the justice delivery system suspect. So, in other words, we are at the prosecution stage, with which we are not for the present. There should not be any insistence of proof beyond reasonable doubt. But prima facie, my lord, your lordship, in my very respectful submission, the conscience of the court is of much importance. Assume for argument's sake, my lord, there has been a torture. Why outside? Because inside there is no evidence. Why outside? Assume for argument's sake, it was inside. Condemnable. Supreme Court has said so. But is it of such grave magnitude that it requires the intervention of the court in the public law remedy? That is the most important question. Now, my lord, following this judgment, but please have a look to, my lord, one, very well, two judgments, then I'm over on this aspect of, my lord, our High Court. In 2013 SCC online, Calcutta, no, 4415. So this is of our High Court. But this is a unnumbered paragraphs over here. Please take away the second paragraph of the first page. It is submitted by C. Bhattacharya, learned senior counsel appearing for the petitioner, that the incumbent suffered injuries by firing by the police. On the report filed by the government of West Bengal, the facts have been denied. Then, my lord, this was a GCB machine, my lord, over there, my lord, a lot of commotion, etc. My lord, now, my lord, please turn the page. Please take me to the second page, but the last paragraph at the second page. In the instant case, we find that there is no serious injuries caused to any person. Police has admitted that they used rubber bullets and lathi charge was also there. In paragraph 6, it has been mentioned that the mob became violent and attacked by hurling bombs on the police personnel and damaged the vehicles. It cannot be said with certainty that it is a disputed question of fact that the police has used firearms or not. It cannot be decided in the writ application. We do not find any ground has been made out to make further inquiry in the instant case. The inquiry has been made by the police and the FIR has been registered. In case any of the injured persons are still aggrieved with the inquiry, it is open to them to file private complaints before the competent court for taking appropriate action. In case any such complaint is filed, the magistrate will hold adequate inquiry in accordance with law without being influenced by any observation made by us. In the aforesaid factual background of the case, we are not inclined to invoke the extraordinary jurisdiction to direct further inquiry into the matter. No compensation be ordered to be paid in the peculiar facts of the case, as the disputed factual matrix cannot be adjudicated in the writ jurisdiction. It has been laid down in Subhe Singh, then the court is considering Subhe Singh, and ultimately no relief has been granted.
Yes.
Therefore, I go back, Miller, to the first point. D.K. Basu said that there has to be an established infringement of a fundamental right. Parameters have been laid down by the court. Please consider, Millard, whether, Millard, a case has been made out which shocks the conscience of the court prima facie. Well, this takes care of, Millard, the second part. I'm sorry.
This is not a custodial torture case, basically. This Justice Mishra's case.
It is.
The earlier cases, whatever it was on in custody, certain things happened actually.
Right. But Rajendra Singh is a custody case.
Rajendra Singh is which ones?
Well, the 2006 3 SCC 170.
Subhe Singh.
I'm sorry, Subhe Singh. Sorry, I'm so sorry. Kindly take me the first paragraph of Subhe Singh.
Yes. Subhe Singh is a custody case that I've seen.
Okay.
Even Alec Padamsey is also not a custody case. Only
No, no,
Subhe Singh is a custody.
that is on the basic law.
Basic law. Subhe Singh is the only case which is based on whatever custodial torture, violence, whatever you described.
Right. But there is another judgment of our division bench, which is somewhat a bit elaborate, which is 2013 SCC Online Cal 22919. SCC Online Cal 22919. Here also, Miller, the prayer for awarding compensation was denied by the learned single judge. They go up in appeal. At paragraph 8, 9, 10, 11, 12, Miller, all the cases 13, 14, 14
8
is
onwards.
15. These are all Miller cases. Now take Miller para 17. But definitely not on the facts of that case. But what the finding is at para 17. The case of the petitioner by no stretch of imagination can be construed to be one in the realm of a gross and blatant breach of Article 21 of the Constitution, resulting from torture, custodial torture, and even ensuing death. But I don't read the rest of it. Please take para 18. It would entail a factual inquiry to establish a reasonable nexus between damages, if any, suffered by the petitioner and the wrongful acts of the respondents prior to grant of compensation, and such inquiry can best be done by the appropriate civil court under the ordinary law of the land. He says, I have done this. I say, I have not done that. The inquiry is to be done before a court which can take evidence. Basically, the court which can take evidence can do this. And in the private public law remedy, it is an established one. But the normal principle, as your lordships have held, that a mandamus is issued only in respect or when an established fundamental right is infringed, or there's an imminent infringement. Because here, my lords cannot look into the factual disputes. Now, this case takes care of the second point. Please take me the third point. I'm sorry, I've exceeded my time.
That I knew actually. Yeah. That is why I have released all the matters.
Now, my lord, the allegation, my lord, your lordship has found, said Nichu Jat. Nichu Jat, Nichu Jate mato thakbe. That's the allegation. By a lady who again does not come from a higher caste or an upper caste. It is within public view. I don't dispute that. Wherever it has happened, if it has happened, the place where they have said it is within public view, I don't dispute that. If it is correct, it is within public view. Now, please take, my lord, I don't think that I need to take your lordship through the SCST Act, but please look into one judgment which considers these aspects. This is 2020, volume 10, Supreme Court cases, page 710. Hitesh Verma. Ekটু দেবেন স্যার? The complaint over there is quoted in paragraph 2 at page 712. Fifth line, Millard, from the top within quotation. Respective SHO, with respect to registering of FIR, the complaint is presently resident of so and so. I am constructing my house at such and such place. So and so people, such and such, for the past 6 months are not allowing the applicant to work on their field. All the above person used to abuse the applicant, her husband and other family members, and used to give death threat and use caste-colored abuses. On so-and-so date, all these persons entered illegally into the 4 walls of her building and started hurling abuses on such and such, took away construction material. The applicant is a scheduled caste, and all of the above person uses caste remarks, abuses, use bad language, and said that you are persons of bad caste and that we will not let you live in this mohalla stroke vicinity. Now, this is what was said. Bad caste will not let you live. In our case, Nichu Jate moto thak. But, my lord, here, of course, my lord, public view has been discarded. But, my lord, on the principles, my lord, I will submit.
But
now,
this is after a post-registration of the case.
Yes,
the consideration.
yes. But, my lord, please consider, my lord, whether, my lord, what is said.
Whether that constitutes an offense or not.
Just prima facie, prima facie. Kindly take, my lord, the statement and objects, my lord, which, my lord, the Supreme Court quotes at paragraph 8. But I would have liked to read in its entirety, but please take, my lord, a portion of it. Please take, my lord, just above Placita G.
Paragraph 8.
paragraph 8, the statements and objects of these statement of objects and reasons are quoted. Placita G, when, where the sentence starting with when on the right hand side, when the scheduled castes and scheduled tribes try to preserve their self-respect or honor of their women, they become irritants for the dominant and the mighty. Well, this is one of the object or reasons for which the existing that act has come. Now on the next page, first line at page 714, under the circumstances, the existing laws like the Protection of Civil Rights Act and the normal provisions of the Penal Code have been found to be inadequate to check these crimes. Therefore, this special legislation. Now, please take me, Lord, paragraph 10. The act was enacted to improve the social economic conditions of the vulnerable sections of the society as they have been subjected to various offences such as indignities, humiliations and harassment. They have been deprived of life and property as well. The object of the act is thus to punish the violators who inflict indignities, humiliations and harassment and commit the offence as defined under section 3. With the next sentence is where I lay emphasis. The act is thus intended to punish the acts of the upper caste against the vulnerable section of the society for the reason that they belong to a particular community. Then we have paragraph 12. The basic ingredients of the offence under 3(1)(r) of the act can be classified as intentionally insulting or intimidates with intent to humiliate a member of the scheduled caste of the tribe and in any place within so and so. Para 13, the offence under 3(1)(r) of the act would indicate the ingredients of intentional insult and intimidation with an intent to humiliate a member of the scheduled caste or the scheduled tribe. All insults or intimidations to a person will not be an offence under the act unless the insult or intimidation is on account of the victim belonging to the scheduled caste. Then kindly take note paragraph 17 and 18. This is a very good distinguishing feature which I found subject to your Lordship's correction. Kindly take me para 17. In another judgment reported in Khuman Singh versus etc., held that in case of applicability of section 2 so and so 3, the fact that the deceased belonged to the scheduled caste would not be enough to inflict enhanced punishment. This court held that there was nothing to suggest that the offence committed by the appellant only because the deceased belonged to scheduled caste. The court held, where kindly take me Placita E. Just below Placita E, there is no evidence. What has found that there is no evidence to show that the offence was committed only on the ground. This is very, very important. Only on the ground that the victim was a member of the scheduled caste and therefore conviction so and so is not sustainable. So when the offence has to be made out or offence has to be committed because he was a scheduled caste. In our case, what is said? That there was torture right, left and center. With that, said Nichu Jat. I read this part once more for your Lordship's consideration. There is no evidence to show that the offence was committed only on the ground that the victim was a member. Then paragraph 18, fifth line. That is not very important. The allegation of hurling of abuses is against a person who claims to have title over the property. If such person happens to be a scheduled caste, so and so is not made up. Therefore, Miller, the crux of my submission over here is, number one, Miller, the lady concerned does not belong to the upper caste. Number two, Miller, no case has been made out. Miller, I quote the Supreme Court's words that the offence was committed only on the ground that the petitioner number one is a scheduled caste or a scheduled tribe. It was, as per their case, in the course of several offences, one of those. If I've understood this paragraph correctly, my lord. I
No.
think, my lord,
Proceed that you are accepting the.
no,
uh,
I am proceeding on the basis of what has been said, because when your lordships consider a prima facie case, what is before your lordship is, my lord, the pleading, the basic pleading. But in the under the Civil Procedure Code, under Order 7, Rule 11, when your lordships are considering a prayer for rejection of the plaint, what is before the court is only the pleading or the plaint only. So considering the plaint only to be correct for the time being, but whether it should be rejected or entertained. But I am applying the same principles, except for the timing, whatever they have said is correct. I am not accepting any of those. But assuming that everything is to be correct, whether these parameters which I have troubled you for the last 1 hour, whether these parameters are met or not. My submission is these parameters are not met prima facie. But take a case, I admit this. But since it has fallen from the court, let us examine that also. Take a.
Because we are at a stage where there is no case. Court is also not thinking in terms of direction for registration of an FIR, but I'm not also thinking in terms of that. To throw away a petition, the only option left before this court now is to throw away the petition. Now, will it not be a denial to for access to justice?
Yes, I'll address your lordship immediately on that. Apropos the first submission, it is a throwing away of a writ petition. Go and avail the statutory remedies on the maintainability part. Apropos the second point on the alleged custodial torture, my lord, your lordship is not throwing away the petition. Your lordship is showing them the appropriate remedy. The appropriate remedy would be where evidence can be taken, he can establish his right and pray for compensation.
And so far as the issue relating to access to justice is concerned.
But so far as access to justice is concerned, my lord, access to justice is in such case to the civil court or the criminal court. Access to justice for infraction of Article 21 in the public law remedy is an established infraction of fundamental right. Today, my lord, we are, my lord, at the stage of an allegation stage.
Not even allegation.
Take it, my lord,
Allegation.
Allegation stage. We are not at an established stage.
No, we are not.
Therefore, my lord, prima facie also, but if these parameters which have been laid down are not apparent to the satisfaction of the court, prima facie, my lord, your lordship will not be denying justice or not be denying access to justice by relegating the petitioners before the civil court or the criminal court according to their choice. But access to justice does not mean access to justice only under Article 226.
So this question I am just asking you only for the reason that the representation is, although you have your reservations regarding the issues, I am not taking that part. If the accusations are rightly, wrongly of custodial torture. Let's say wrongly also. You said rightly, I say wrongly also. Now, in case the petitioner has approached the court with such a representation which was advanced, not considered, in none of the cases at the first instance, they were thrown away. Whole of the judgment.
I get you.
So the court considered everything and thereafter decided and came to the finding at a much more later stage, I would say. So, in fact, I think the High Court judgments are of division bench
All
judgments.
after, all after. No dispute on that.
So, in those cases, it can be presumed for the timing, they were not at the first instance denied any, I don't say justice, access to justice. There is an accusation of violation of fundamental right, and a party has approached the court for an access to justice. According to you, there are other avenues open. That's one of the answers. But then, is it not the duty of the court to ascertain regarding the truthful of the accusations concerned over here, sir?
But
And then whatever comes up, decide, because decide the issue. That is what is going on through my mind. Otherwise, in a similar case, I would not have passed an order. There also, I have not said that register FIR and start investigation. I have not said that, sir. What is bothering me over here is also, we go access to justice is also encompassed within the Constitution.
Right. Article 21 itself conceptualizes access to justice.
Now, once a party to a litigation has approached this court, admitted part is this, up to this, nothing more than that. They were taken into custody, they were released from custody. I mean, to the police station, this part is not omitted.
Not
This is
disputed.
not disputed by both the parties. They have come up with accusations of certain issues relating to physical torture being inflicted upon them. They had made a representation, and such representation, obviously, as usual, is not considered. Now, is it that at the first instance, the High Court should throw away the petition?
My lord, on the second aspect, first aspect, Lord, I said the writ petition itself is not maintainable. Whether your lordship is going to dissect the relief and relegate a part to the through the normal statutory process, or my lord, relegate the writ petitioner in its entirety or on all reliefs to the respective courts, that is, my lord, for the it's the court's discretion. But ordinarily, my lord, courts would not or are not inclined to dissect the reliefs. If I succeed on the first point, I believe, my lord, the others should go along with that. But be that as it may, my lord, in respect of the second point, atrocity point, assuming the writ petition is maintainable, where the greater discretion lies on the...
And not an atrocity point, sir. Atrocity, you have shown you have your own points regarding an afterthought, factual circumstances. That's an acceptable part. Access to justice point.
Yes, access to justice point, what I'm saying, Miller. Access to justice is maintainability qua entertainability. I presume, for argument's sake, this is maintainable. The discretion lies with the court whether or not to entertain. That is, now, whether or not to entertain, assuming for argument's sake it is maintainable, to entertain, my lord, the parameters which has been laid down by the Supreme Court, in my very humble submission, has to be prima facie satisfied. My lord, please consider this, my lord, writ court is a discretionary remedy. When, in order to, my lord, invoke the discretionary jurisdiction by a 226 court, my lord, the burden is heavy or heavier on the petitioner to make out a case on the pleadings on the first day, at the first instance, at the first glance, that it requires a probe. I won't say probe, because probe is possibly not a correct expression. My lord, a judicial review by the court. My lord, denying to entertain a writ petition in very respectful submission will not in all cases result in denial to access to justice. What is access to justice? Well, access to justice is to go before an independent forum and get the points of the disputes agitated, resolved, judged, enforced. Well, I give you Lordship an example, but since your Lordship is thinking aloud. Well, this petition is entertained today. Certain directions are passed today. Tomorrow I come with a affidavit in opposition denying all the allegations. Bald denial. It becomes a disputed question of fact, especially cases of this nature. And a disputed question of facts, if it arises in a writ jurisdiction, it is not that it has to be always thrown out. The court will see whether from documents on record a disputed question of fact can be resolved on. My respectful submission is, Milord, if tomorrow I come up with an affidavit saying that everything is wrong, Milord, your Lordship would be handicapped, kindly not take me amiss, in deciding such disputed questions of fact on the basis of documents on record. Please consider this, Milord, because this has got a, some sort of a repercussion, Milord, for the future. Because my concern is more important, though his concern is not less important, but is that, Milord, this tendency is also to be looked at. Somebody taken to the police station comes out and says that I have been thrashed inside. This may become a trendsetter. Therefore, Milord, watertight cases, in my very respectful submission, only are to be entertained. Now, please consider, Milord, for the time being, where the loose ends or, Milord, the missing links. One injury, nothing before your Lordship today. It is not that nobody was aware of whatever has happened inside, because in the afternoon, Milord, their leaders went outside, inside the police station. The leaders were not prevented from, Milord, sending an email or going to the sending an FIR, going to the SP's office. No case went out. The leaders possibly waited. I do not know whether they had waited all along or not. Possibly waited all throughout till they were released, because when they came out, they found the leaders were over there to, escort them to their respective homes. Leaders, plural. Now I go to the police station to lodge a complaint. I come out and say that the police has snatched my mobile. Very easy. That is why the Supreme Court uses the expression whether it is first is patent indefensible. I am saying it is defensible. These are the factors please consider. Number two, this is the first aspect. Leaders were there, no complaint, no contemporaneous complaint. 3 days, no explanation why they waited for maybe 2 days. Why for 2 days? Number two is alleged non-cooperation by the medical college at Midnapur. Comes.
Mr. Dottu, it's 1:32.
Yes, sorry.
I would like you to address on access to justice.
Very
Tomorrow 4 p.m.
Only probably.
1:45 it is starting. After 4 p.m., nothing will remain there, sir.
The problem is, my lord, medical, why we are placing for at least a medical board, my lord, they were having injuries. And my lord, slowly, the injuries are, my lord, going away, my lord. That's why, my lord, at least at the medical board, at least they should have been appeared before a medical board. My lord, I'm not saying about SC/ST Act Commission, but
No,
my lord,
what you are saying is not more important. What is more important is over here the probability. I'm thinking in a different manner this case, and I have to balance between both the things what Mr. Dotto has said, and obviously
today
the
they are-
anxiety and agony for which you have approached
my
this
lord,
court.
my lord, my lord.
Otherwise, I would not
Today
have.
they are saying about access to justice. Question arises what they did from 6 to today's 24, 12th. What they did, where is access to justice? My lord, 4 girls, they are admitting that those girls were left from the police station at 2:20. What they were doing inside the police custody, what they did, any case has been started. Why 4 girls were taken away by police? All right, police did not do anything. But is it not shaking our conscience, my lord? Why police took those 4 girls to police station? Why they kept over there for 15 hours?
Uncommon. It happens everywhere
Acha,
where
is it
agitation
not?
takes place.
It is common, and we shall support this because police they have tortured 4 girls.
No, normally it is expected after around sunset they should have been left out, sir.
Why they were kept inside the police
That is
station
an
for 15
issue.
hours?
Anyway,
That is an issue which your lordship will address. No doubt about that.
I want to address, sir. He is appearing for. I'm whatever is in my mind. I'm allowing him to ventilate that, sir.
He was accompanied by one lady.
So let him complete. He has not completed. I will want him to address under these circumstances. This may not be one of the cases in a true set of facts or circumstances. You are arguing on the foundation that you are disbelieving the factual circumstances. There may be a true set of circumstances is also where there is no medical report also. A person has been thrashed, but then whether at the first instance the record, if you have something authority or
Regarding
anything,
that, my lord, we have our answers. They firstly, my lord, when they were taken in the custody, there is no medical report, and that was the duty of police to take their medical report.
But I would request my friend to confine himself to the pleadings. I have not gone one word beyond the pleadings.
Mr.
Please kindly half an hour, my lord, half an hour for us.
More than that, I will give you. More than that, I will since just because this is a balance of the court to be drawn, whether at the first instance, whether see repeatedly entertaining the petitions will also multiply the cases. Number one. Number two, throwing away of the petition
Absolutely
may
right.
increase the number of custodial torture.
Right,
Yes, yes.
That is why I am on access to justice point. Whether at the first instance, the High Court will not consider anything. Both. This is a very tricky situation.
Yes.
That I'm not saying whether it has been done, whether it has not been done, because all the cases which have been referred to were at a very final stages of the cases.
I quite appreciate.
That is why I come to the basic point: access to justice of the persons who approaches this court, balancing between where multiplication of. In fact, there are many cases also where in custodial violence was questioned also. There are also cases also that there is hardly any evidence in cases of custodial violence. Not possible for person to obtain
My lord,
evidence.
absolutely, like our case.
So let us say
Email pattern.
Can it be at 12 tomorrow? 12?
rest of the litigants will suffer. You understand? And the fresh motions are and that's why at 4 o'clock
At 4 o'clock, after coming back.
you do and come back.
কালকে 4 o'clock.
What is it? It's become very difficult for me. This type of cases is continuing.
My problem is, my lord, second half, my lord, all other problems except the, I mean, administrative work that I have. But kindly, my lord, I won't take more than 15-20 minutes.
No, because you take 1 hour, sir. I have got
No, only on this point. Because I have.
Yeah,
Yes.
The queries.
নিশ্চয়ই দেবে কেন দেবে 100 বার দেবে 200 বার দেবে
It's almost like a hearing going on basically on the
Yes.
point of admission. আর কবে তো ডেটও নেই তো আমার নেক্সট উইক শিফট টু নেক্সট উইক
Monday then এই মানডে না,
তাহলে
এই বুধবার করলে অসুবিধা আছে তোমার? সামনে বুধবার
না আমাদের সোমবারও অসুবিধা নেই স্যার।
আমাদের সোমবার আমি নাও আসতে পারি।
লং হলিডে
না, না, রবিবারই যাচ্ছি।
ইয়ে করো না মাইলট, বুধবার, হ্যাঁ বুধবার হোক, আর কি করা যাবে, আর মঙ্গলবারও হতে পারে।
না, মঙ্গলবার অসুবিধা নেই।
থাকবেন না বুধবার না,
বুধবার, বৃহস্পতিবার, শুক্র করো। এই রে,
শুধু শুক্রবার কি করে হবে তোমার?
তাহলে বুধবার at 3 PM বা 4 PM থাক, সব কাজ সেরে।
3 p.m. Wednesday 3 p.m.
19th on at 4.
3 p.m.
3.
All right.
ঠিক আছে।
Thursday, 20th, you were there.
Yes,
And
20th.
if it spills over, maybe for Mr. Chatterjee, it may spill over because
Mylord,
he's getting 1 week's time, means he'll bring another 10 judgments.
because Mylord,
2 judgments.
yesterday, one word we didn't hear, this compulsion. I know, we all know, Mylord. We didn't hear the word compulsion, but again 10 judgments will come.
No, but I have got to decide, sir. I am not on that. And he's entitled to keep that. I will also grant you opportunity because first I intended to hear from the state so things can be made small, sir, as it happened in the earlier. Now, he has started arguing the matter. He has, in his own manner, placing the case, raised the issues. And I have also confronted him with whatever there is in my mind, sir. All on a sudden, he will be placing his judgments, and on access to justice point, I will decide a case that I will never do it.
Right.
That would have been easier for you, only that I would have kept silent and gone on a different issue on this access to justice point. That I will never do, sir. Let him argue the case on that point. That's a very basic point. All the cases which we are dealing with are at the final stages, actually.
Absolutely, my lord. Shall show, my lord, I have gone through all the citations which were placed by my learned senior friend. I shall show that none of the judgments are applicable in this case. I shall show.
ঠিক আছে আর এ কি আচ্ছা মিস্টার আচ্ছা লার্নার অ্যাডভোকেট এ জেনারেল continues with his argument and intends to continue with the same. On 19th of March 2025, released the petition under the heading specially fixed matters at 3 p.m. আর একটা কি বলতে যাচ্ছেন মিস্টার দত্ত, Mr. Maiti was there, Mukteshwar Maiti was there, Romeo. Yes. Have you
Today, my lord, your lordship is once again sitting. There are some
upgraded matters?
330 matters, specially fixed. It will
That will not be taken up, sir.
Specially fixed matters are not taken up. All right.
Up to 3:15, I will sit. Thereafter, I have got to go.
Grateful, my lord. Grateful.
Miss. Hundred and seven form. Huh? Should I pass an order direction? How much time do you want? So if I dispose of this matter, difficulty is that this issue will not be solved. This is a greater issue, actually. I am bothered about this one and that arrest communication rules. When should I keep this matter? After 2 weeks? আচ্ছা এই সঞ্জয় বাসু ম্যাটারটা কত নম্বর আছে?
173.
173 তে একটা অর্ডার নিয়ে নিন না। Mr. Mukteshwar Maiti, learned advocate appearing for the petitioner, is present. Mr. Dotto, learned advocate general, would Mr. Learned advocate general submits that he has had an interaction with the administrative authority who are yet to send instructions to him. full stop, accordingly list the writ petition under the same heading on 26th of March 2025 under the same heading. Sure. Any other matters you have today or no? Huh? No, today earlier, sir. Wow. No. হবে আর কি no 2:30 no sir 10 past 2 sir 10 past 2 1 hour at least I'll take the upgraded no I 3:15 I have got to rise sir otherwise I will not be able to reach there হ্যাঁ এইটা একটু রেখে দিন চলুন আমি 2:10 বসে যাবো 3:15 উঠে পড়বো চলুন
142.
Yes.
This is a very unfortunate event. The petitioner's elder brother, being 69-year-old, a senior
Yes.
citizen, went missing on 15/4/2024. His phone was not traceable. Nowhere he could be found by the relatives. On 17/4/2024, one GD was
Yes,
lodged.
what is your report? When is your report dated?
Lord, it has already been 1 year. I bow down to your lordship, but the GD entry was first done on 17/4/2024. We do not even know whether he is alive or not even.
This is before whom? Who is
Bajar.
inquiring? Barakpur Police Commissionerate?
Yes, my lord.
Missing Persons Bureau CID I am giving this matter. No case is there. Page that a player was also in the missing person will say any publication. As I also said, they have sent. Basically, they are seeking the assistance instead of directly let them do it because there is no case. You have got to trace out the person concerned. The machinery is available with them. Simple thing, sir. Why would the repetition come repeatedly? This can be disputed. They are the person specialized to do the job. Let them because there is no case at all actually.
May I be handed over a copy of the witness?
That you can. Acha.
Hand over this report. I cannot say anything, but this is not the daughters and wives.
Who is this person?
I am the sister, younger sister, my lord. And my lord,
Investigation authorities have made, but I'm subject to correction. I'm not inclined to give this report. Lordship is handing over the
I beseech your lordship.
Your lordship, but what the police authorities
And appears.
Subject to correction.
I bow. I
No,
bow
at
down
least
to your lordship. but
wait. At least give him a sketch within 48 hours regarding the steps taken. May not be in this format where what you are submitting to the court. Indicate a sketch that what steps have been taken till 1 week. Please hand it over. I'm disposing the petition. He'll give a sketch. May not be the exact in the form in which it has been placed before the court, but a person who has come to court is entitled to know regarding the whereabouts of the person.
My lord, let me indicate just one small thing. In my paragraph number 10, I have indicated the GD entry was made by me and the niece, the nephew of the missing person, not by his son, not by his wife or the daughter-in-law, because they did not have a good relationship with him. And I think
whatever that is, there there is no case. You have not come up for that. A cognizable offense is made out.
Absolutely.
It's only to trace out the person concerned.
Absolutely.
Petitioner has expressed his anxiety as his brother is not traceable. His brother, namely Shapun Kumar Mondal. What is the name? Shapun Kumar Mondal.
Yes, my lord.
The person who
has gone missing.
His brother Shapun Kumar Mondal is not traceable, and in spite of repeated informations being sent to the Commissionerate of Police Barakpur, to the Commissioner of Police Barakpur Police Commissionerate, till date, there has been no outcome in respect of the steps taken by them. Full stop. I've considered the agony or the anxiety of the petitioner and also taken into account the steps taken by the officer in charge, Nagerbajar Police Station, Barakpur Police Commissionerate, in respect of tracing out the missing person. I find that some steps were taken and necessary coordination was prayed for from the officer in charge, Missing Persons Bureau, CID. Having considered the time period which has passed and the expertise involved in tracing out missing persons, I am of the view that whole of the file relating to the inquiry being conducted. There is no case basically. Inquiry you are conducting.
There is another aspect. I appreciate the attorney of the red petitioner. He is forthcoming before your lordship through a power of attorney holders. My lord, having said that, the way this power of attorney has been drafted, in respect, my lord, this is not, my lord, subject to correction.
That substantially
Properties mentioned. My lord, kindly have a look at the power of attorney.
No, you say the person is dead.
That is not the issue. What I am saying, my lord, the power of attorney is executed in respect of one Somor Maji. But he has approached, he has affirmed the affidavit. Now the power of attorney says in respect of properties he has given certain powers. In respect of his brothers when missing, but the Somor Maji will affirm affidavit. Lordship, can you see the power of attorney at page, after the page 18, 19, yes, page 20 onwards the power of attorney. Lordship, kindly have to look at the language of the power of attorney.
The Wakalatnama is of Aarti Ghosh.
Yes,
Wakalatnama is not of.
Scheduled property. What is the scheduled property? Paragraph 6 also.
But kindly look at her age.
Schedule
At
is
this
also
age.
missing. But am I to understand they are considering? But I should not.
But you are not investigating any case.
Yes,
The power, but I could have understood Shopon Maji had filed the Wakalatnama before this court. So I can ignore that affidavit totally. Aarti Ghosh has signed this. Now you can say whether this is a signature of Aarti Ghosh. Then I will take steps.
Yes,
So why this? This is not a cognizable offense being investigated into, sir. चलो चलो ऐसा কি বললাম inquiry for tracing out the say 8 Shopon Kumar Mondol be transferred to the officer in charge Missing Persons Bureau CID Bhavani Bhavan West Bengal. The concerned officer will exhaust all the steps as is professionally done by the say department and every 2 months inform to the petitioner once in every 2 months inform the petitioner relating to the stage which to which they would arrive. Also, with the aforesaid observations, WPA number 28222 of 2024 is disposed of. Reports are submitted, be kept with the record. A summary of the report be handed over to the petitioner by the learned advocate for the state within a week from date. Chalo, I guess. Having expertise.
I'm grateful, Mira.
I am for the petitioner lordship. I am praying for not to the lordship.
Sir, this cannot. You will pray for upgraded motion. Earlier, this is none appears for the petitioners. Earlier order.
Senior is out of session lordship.
Then why did you mention why are you mentioning these matters? I have got to wait, sir. এই আর কিছু করা যাবে না।
Kindly make it not to the
না
lordship.
না, what are you wanting? I read quash status I resign 2024 charge sheet submitted. Huh? তো ঠিক আছে। চল্লিশ petitioner approached the East Court for quashing. এটা কি আমতা PS or what is the case? Amta PS case number 170 of 2024. On the ground of certain factual assertions. Full stop. Learned advocate 8 for the stay 8 submits that the investigation of the case is still in progress. Learned advocate for the private respondent submit earlier they were in respect of the same FIR. A challenge was in connection with 170. Then learned advocate for the respondent submits that the present case has been the present petition has been filed in order to divert the investigation which is in progress. None of the contents which have been in advance in the petition do require consideration of this court. Full stop. Next paragraph. Having regard to the fact that the issues advanced by the petitioner do not fall within any of the parameters settled by the honorable petitioners. Do not fall within any of the parameters settled by the honorable apex court, and the fact that truth or falsity in the allegations cannot be gone into at the stage of investigation. I am of the view that no interference can be made. Petitioner would be at liberty to canvass all the issues at the time of consideration of charges. Cholo, with the aforesaid observation, WPA. What? বড় করে জাজমেন্ট দেবো আর সময় নেই এখন।
Not the judgment passed by the Supreme Court in this context, but the Bhajanlal and all they were also indicated but not
আচ্ছা ঠিক আছে, ওইগুলো
but not named.
ওগুলো দিয়ে দেবেন তো, ওগুলো ওই একটা আমাকে পাঠিয়ে দেবেন একটু একটা ব্ল্যাঙ্ক করে আমি
Compilation
ইন দিস কেস না আলিয়া ও অনেক মামলা এগুলো অত বড় মামলা না, পিটিশনেরই মামলা করতে চাইছিলেন না, কিছু দিতে হবে না। With the WPA 28412 of 2024 is disposed of server copies. Next. কতগুলো আছে বলুন করতে পারবো?
Battle over a দেবোত্তর সম্পত্তি।
This is a matter where there are several land grabbers
ভালো
who
কথা।
are trying to grab the land of a Devottar property. There is also already an ad interim injunction in the property.
Very
Both
good.
the parties approach the civil court, both the parties got the order of
Injunction.
status quo. And my lord, admittedly, the respondent
My lord, may I submit?
once
My
made an
lord, may I
attempt
submit? I am the
to build up Mondir, my lord, but that was been stopped. And as on date, the land is lying vacant.
My lord, as my learned senior friend submitted very rightly, but thing is that pursuant to injunction, they were restrained to make any changes and encroachment. But the private respondent, time and again, with their local influence and local political support, they are encroaching. To that effect, there is a GD. After that GD, there is again a complaint which is lodged before, my lord, SDPO at page 33, my lord.
So you go before the civil court and inform the court to take action.
My lord, it is informed, but that
151 have you filed?
Not yet, my lord.
তাহলে কি করে করব?
But that, my lord, I have
Petitioner
on date, the land is lying absolutely
আচ্ছা
vacant.
petitioner is agreed
And we
by
are
the
keeping a strict
আর
vigil.
কিছু নেই বাবা এই মামলাগুলো যা 151 করলে পুলিশকে ডাইরেকশন দিলে করে দেবে।
151 was done previously, pursuant to which there was a GD. And my lord,
151 where is the
But,
where is the direction upon the police authorities?
my lord, I have to take instruction.
No,
regarding
করেই নি।
that.
But my lord, may I
petitioner-
candidly submit only one thing, my lord. My lord, if this be the thing, then my lord, process will become punishment. There is usually a injunction in civil case. Then he has to again do an 151. Then
So
again,
that's a procedure of law. How can you avoid that?
I bow.
Under Article 226, I will do the
My
thing.
lord, your lordship has inherent power. I leave before your lordship.
Petitioner is aggrieved by the
liberal
fact that
approach.
petitioner is aggrieved by the fact that in spite of directions passed by the learned civil judge, পুরো পাতা তো দিতে হবে বাবা, কোথা থেকে পাতা দিয়েছে দেখো, জজের নাম 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 মরিনি।
My lord, injunction is at page.
আর injunction I say, where is the judge? Which judge?
Complete annexure.
Page 25, my lord.
25, where is the judge? Civil judge what? এইসব পাতা দিয়ে মামলা করে যাচ্ছে, তারপর রাইট ক্লেম করছে। হ্যাঁ, কি ইনস্পাইটার অফ ডিরেক্ট কি হলো?
Civil Judge Junior Division, Diamond Harbour Civil Court.
ওই সিভিল জাজ জুনিয়র ডিভিশন, which court?
Diamond Harbour Civil.
ডায়মন্ড হারবার একটা সিভিল কোর্ট জুনিয়র ডিভিশন আছে? সিভিল জাজ জুনিয়র ডিভিশন পরে দেখবো। এসব বলছি তো, এইসব মামলা দিয়ে যায় আর নিয়ে নেয়। First additional court, Diamond Harbour, in TAS 371 of 2024. The private respondents had been pursuing their illegal activities and are violating the order passed by the learned civil court. To that effect, informations were furnished with the police authorities, but the police authority is restricted themselves in recording a GD entry and did not respect the order of the learned aid civil judge. Full stop. State has submitted a report. Report reflects that the civil case has been initiated by both the petitioners as well as the private respondents. ভালো করেছে।
It is in point 7, third page.
Being title suit number 371 of 2024 and title suit number 412 of 2024. Full stop. Acha. Since the dispute is already before the civil court, naturally without a specific direction upon the police authorities, they are unable to execute and or implement any order. Full stop. Petitioner therefore is granted liberty to approach the civil court with an appropriate prayer for rendering police assistance in respect of the status quo order and or any other order being flouted or violated at the behest of the private respondents. Full stop. If the learned aid civil judge passes in the direction upon the police authorities, appropriate assistance will be rendered by them, and the police authority would respect, obey, and implement the order of the civil court. With the aforesaid observations, WPA 28446 of 2024 is disposed of. The reports are submitted. Be kept with the record. A copy of the report be handed over to learned advocate appearing for the petition. Next.
My lord, evidence service file.
Evidence service check to the next. State. You are the state, madam. Yes.
But what private respondents?
Same be handed over to learned advocate appearing for the as well as learned advocate.
They are coming to my house,
View of the supplementary state
family
request.
members, abusing them with.
You have a fresh report.
Yes, subsequently, my lord.
Last report only because 107 has been instituted and
No, these are after 9/12/2024.
What has happened?
this
I
one is
filed a
the
supplement.
5/12/24. This is the 5/12/24.
No, I directed to file a fresh report after the supplementary affidavit was filed.
Because over there, after filing.
Supplementary, no copy has been served to us.
Yes, learned advocate was there.
State you
Then kindly of 7 days time, Lordship.
Because after filing
ঠিক আছে।
petition, I lodged a complaint.
Release the writ petition under the upgrade matters দিয়ে সামনের সপ্তাহে দিয়ে দেবেন। Release the writ petition under the same heading on 1 week enough. আজকে কি বার বুধবার তো 19 তারিখ on 19th of March 2025. চলো next.
46.
I am for the petitioner lordship. I am praying for not to the lordship.
এইগুলো কিরম রাগ ধরে সকালবেলা 1 ঘন্টার করে সব
out of
মেনশনিং করবে, কালকে সকালেও আবার আছে, একই জিনিস করবে সবাই, তারপর এখানে যে টাইম চাইবে। ক্যান ফাইল করেছে,
Can copy of the can.
কিসের জন্য ক্যানটা ফাইল করেছে তাও জানি না আমি।
I have not received any can application.
ও, take up the writ petition expeditiously. Month list of June 2025. An accommodation has been paid for on behalf of the petitioner. After the writ petition was upgraded, learned advocate aid for the state is present.
Well, this can is disposed of.
হ্যাঁ,
My lord.
আচ্ছা, paid for an accommodation বলেছি তো, হ্যাঁ। As the an application for expeditious hearing of the writ petition has been filed. According in view of the writ petition being called and accommodation being paid for, CN 1 of 2024 dismiss করবো নাকি?
My lord, disposed.
Is disposed of. List the writ petition in the month list of June 2025. করবে না জীবনে এগুলো। না না, কিছুই নিয়ে হিয়ারিং এ কি করবো দিয়ে, এরা যে বেঞ্চ আছে করবে। As a petition to certify regarding the survey is being পেজ কি করছে না কেন, লোকে মামলা আপগ্রেড করে। মহা জ্বালা হয়ে দাঁড়িয়েছে এগুলো, 1 ঘন্টা ধরে সব মেনশনিং করে। None appear as for the petitioner. Mr. Dotto, learned advocate, aid appear for the state respondents. Release the writ petition in the monthly list of June 2025 under the same under the heading motion. আগেরটাও করে দেবে যেগুলো, হ্যাঁ। Next. দিন
May it please your lordship.
হ্যাঁ,
So I am for the petition.
এই ফাইলটা
Lordship will recollect, my lord, on the last occasion of
I am for
30th of
private
January.
respondent.
where is
My lord, there was a specific direction, my lord, upon the state.
এই
Thereby, my lord, the two documents
report
which are
submitted
annexed,
aid by the state be also kept with the record.
supplementary affidavit,
And
my
the
lord,
end of
saying
documents
that, my lord,
has not been dealt with.
this is my land. PWD has nothing to do with
Yes,
this.
after 30th January, have you got a report? পাঠাইনি, হ্যাঁ। No, last I have
These report, this document, I am showing 2 documents, my lord.
Yeah.
This report, I talk to my officer. Can you have a do this?
Which date report?
This is the date, 29.
January 2000. Then
Finally, government of West Bengal, assistant engineer, third page.
third page.
The officer interest, here, my lord, annex all these documents, my lord. Some portion of them, my lord, petitioner, even my lord, private respondent, my lord. Both are, my lord, this is the government acquisition.
PWD.
Ask of my lord, government acquisition.
This is completely wrong submission. These things, my lord, Mr. Chakraborty had appeared. Let me be honest to your lordship. But he is making all false submissions. Your lordship was specifically, my lord. No, please, you don't have to argue. Don't have to argue this. You show the paper. No. Sorry, you cannot. My lord,
This writ petition is not maintainable, my lord. My lord, because of section 11 of the CPC. It's a res judicata. The prayer, my lord, already made in the earlier writ petition, rejected by the honorable court, not been appealed again.
So file your affidavit in opposition, sir.
My lord, may I? My lord, these things what my learned friend is submitting today.
I know.
Your lordship on the last occasion, my lord,
Hard it.
my lord, kindly, my lord, allows me. Their submission was that this is a PWD land. My lord, I have shown drawn your lordship's attention to 2 documents where it proves that it is my land. PWD has nothing. My lord, kindly seize these 2 orders. Akbar, please. Kindly seize, my lord, this order. What are they saying? My lord, only it is in respect of installing a grill. And for that, my lord, I'm being harassed in my premises. This private respondent, they are in the PWD land. They are the state is supporting them with deepest respect. And can you see the record?
You are prayer.
They are only seeking for installing a grill with deepest respect. Can you see the prayer?
So,
I'm ready.
but they are disputing regarding the construction of the shop room, Naki.
What has happened, my lord? Everything, my lord, government acquisition
No,
some portion of
Hare.
land, my lord. After that, my lord, 50% of land, my lord, return to this, my lord, to the owner of this property, my lord. Even also after that, my lord, entire my lord, area, which is, my lord, government acquisition land, my lord, they have constructed.
Hare.
They are not, my lord, even also portion of this land,
What
they have
are what is he
construction.
saying?
My lord, this is not their land.
It is my land.
50% land is government land.
PWD, kindly, my lord, can you take the supplementary affidavit?
And government land. কোথায় খালদারে নাকি?
No, 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 no. Can you take?
Kindly see the prayer in the earlier petition. Kindly see the prayer.
Lord, kindly takes the supplementary affidavit.
Kindly,
Lord, page.
there is a pencil mark. Kindly see the prayers in the earlier petition.
Research. Commanding cruiser to TNC ships obstructing, disturbing, impeding the business. And further commanding
The first
Oh,
prayer,
এটা
my
তো
lord, to set up a grill on the gate. Now, my lord, kindly see page 13 of the supplementary affidavit.
same prayer you have made.
Kindly see page 13 of the supplementary affidavit. Kindly see.
Just 1 minute, sir. I'm asking him a question.
Sorry.
Hold the patience. You have raised a point. I'm asking him a question. He has got to answer that. Mr. Ahmed, you see your prayer over here at page 10.
Page 10. Yes, my lord.
Page 9, my lord, first prayer.
9A. And
Yes,
you
sir.
are orally saying this for setting up the grill. This is your prayer only.
Yes.
This is your prayer. But this prayer you have already made in earlier petition. He claims it. You see this. আরে ও বললে you see
আপনি প্লিজ চুপ করুন
এটা একটু ওনাকে দিন
read petition number is here.
ও দিয়ে পেয়েছে একটা
This is the repetition.
This is the earlier way.
Yes.
And there is a prayer in respect of setting up.
Saves,
Now, may I just may I see last the order which was passed, which has been annexed in that writ petition. Order to the
Page 13 of the supplementary affidavit. Page 13 of the supplementary affidavit, my lord.
Yes, my lord. Can we see page 13?
Fourth paragraph started, my lord, after hearing the learned advocates. For the parties, this court finds that there is dispute with regard to the title and possession in respect of the immovable property between the petitioner and the private respondent. In view thereof, the petitioner is left free to approach the appropriate forum in accordance with law. Well, this forum cannot be 226, my lord.
You've got to go in appeal against the order if you're dissatisfied, sir. Because this is a second prayer in respect of the same.
That is unfortunate. My lord, I bow down to your lordship, my lord, so far as this part is concerned, as my learned friend has stated, but I was not aware of. What I was only saying, my lord, today, my lord, this installation of grill, it is in my own premises.
I understand that,
Now,
but
what
then
is happening, my lord, I will not take much time. What is happening? My lord, the entire egress and ingress, my lord, it is complete. My lord, if I do it with my own cost, but what's troubling them?
But then I cannot, sir. Once a coordinate bench has considered that, in all fairness, you understand.
I go down. Yes, I cannot.
Chalo.
Should have been challenged before the appeal. Apni abar read file kরেছে।
Acha. Learned advocate 8 appear done. Learned advocate 8 appearing, but then you must give opportunity to the other side to answer.
Yes, yes,
sir.
sir.
He is faced with an answer. He is defending and appearing for a client, and person who has approached a high court. I always feel a person who has come to high court has
seen the prayer.
has come up with pains before the high court. Nobody comes up without any cause of.
Gone through the prayer as my prayer portion was-
ও করে দিয়েছি তা আবার দেখাবেই দেখো হয়ে গেছে বলেছি তো since
He's very excited. The problem.
there is nothing to be excited, sir. This is part of the profession. This goes on, sir. Acha, petitioner has approached this court with prayers amongst others. For directing the police authorities and their main and এটা একটু করে দেবে এই ফার্স্ট পেয়ারে এই পেন্সিল দিয়ে মার্ক করে দিচ্ছি এই অ্যাপ্লিকেশন এটা কনস্ট্রাকশনটা একটু দরকার হলে বদলে দেবে হ্যাঁ একে নিজের মতো করে এই 7/11/2024 ঠিক আছে হ্যাঁ it has been pointed out by the learned advocate appearing for the respondent number
5 to 7 lots.
5 to 7 that similar prayer was advanced in WPA
23462 of 2020.
23462 না এখানে বলেছি 13 নম্বর পাতায় আছে
In my supplementary opinion.
হ্যাঁ 23462 of 2024 আচ্ছা the same was considered by a coordinate bench and wide order dated 3/10/2024 it was directed that the petitioner would be free to approach the appropriate forum in accordance with law. Full stop. In view of the observations of the coordinate bench, present with petition, the prayers advanced in the present with petition do not call for any further interference. Petitioner would exhaust the remedies which have been granted aid in WPA number 23462 of 2024. Chalo, with the aforesaid observations, WPA 28900 of 2024 is disposed of.
Your Lordship, with this line to be added, my Lord. Your Lordship recollects that your Lordship had directed them so for us 2 documents which were concerned in my supplementary affidavit that you have look into this whether these are genuine or not. To that effect, my learned friend has not filed. Only my Lord records it, my Lord. Then it will be helping me in.
The state has not submitted a report. The state has not submitted a report as was directed in the order dated 30th January 2025. However, having regard to the press and the directions made above, I am of the view that the same need not be gone into while disposing of the present petition.
I'm grateful.
I appear for the private respondents, my lord.
State, a petitioner.
I have taken out an application, my lord.
কিসের জন্য?
Appropriate order.
For appropriate order.
But we have also filed the lodged an FIR against the private petitioners, my lord.
কি হয়েছে? এসব দাস What are you wanting? এটা মারধর চলেছে তো। হ্যাঁ। ভালো কথা। Madam, you got a report.
Lordship, PS cases have been filed in.
Which date representation you are wanting? What is the date? What is the date? 43? 26/11/2024.
Yes, Your Lordship.
26/11 case number gulo dekhi.
Your Lordship, PS cases have been filed. The accused in both the cases had been arrested and all of them are on bail. Your Lordship, have been released on bail. Subsequent even. Investigation is going on.
দিনের মধ্যে ওয়েট তখন আমি আমার মতো ও কাকাতো ভাই প্রতিবাদ করলেন ইনি ব্যক্তি রড কাটেনি তার ভাই হাজার 30/10 ঘটনা ঘটেছে তারপরে 30/10 চলছে আমাদের তারপর এই সমস্ত ব্যাপার আমাদের উকিলবাবু সেই তারিখে পুলিশকে একটি লিখিত অভিযোগ জানায় 19 পুলিশকে আবার একটা লিখিত অভিযোগ জানায় আবার আমাদের বাড়িতে ঢুকে তারপর নিম্ন ভিত্তিতে আমাদের বাড়িতে ঢুকে আমার বউ মা ও কাকু বাড়ি ছেড়ে চলে যাওয়ার জন্য হুমকি দিতে থাকে হুমকি দিয়েছে হুমকি দিয়েছে এ করুক হ্যাঁ
But we have launched FIR on 31st October 2024, my lord.
The incident is after that.
My lord, all along, my lord, there was a police picket, my lord. My lord, since my lord, 31st October till
All right, I'm
27 October.
directing them, the officer in charge, to consider the representation.
Already, my lord, case has been.
Is going.
That is an after that 31st October.
Your Lordship.
Ah.
But as on date, Your Lordship.
There are two allegations. One is that these respondents entered their house, threatened the female folk. Two, there is one vehicle number given, which they say they had taken away forcefully. So, police authorities will consider that. If they don't think, they will communicate the outcome to the petitioner. Petitioner would be at liberty to approach the jurisdictional
And my
magistrate.
lord, we are, my lord, that denying the allegations, my lord.
Solution. Petitioner is aggrieved by the fact that in spite of information being furnished on or about 26 November 2024 to the officer in charge Jagacha police station, no steps have been taken. It has been categorically stated by the petitioner that the incidents complained of are subsequent to the police cases which have been registered on 31st of October 2024. Acha. As the incidents reflect that the respondents threatened the woman folk of the family, and also there is an allegation of a particular vehicle being taken away at the by the respondents. I direct the police authority is to consider the representation dated 26/11/2024 in accordance with law, and inform the outcome of the same to the petitioner. Full stop. In case the police authority is of the opinion that no case is made out, the petitioner would be at liberty to approach the jurisdictional magistrate under section 175(3) of BNSS. The learned aid magistrate would assess regarding the nature of the offense, ascertain whether a case for investigation is made out, and then pass orders in accordance with law.
But kindly record my.
With the aforesaid observations, WPA 988 of 2024 is disposed of. Reports to submitted aid be kept with the record. একটা application ফাইল করেছে।
Yes, ma'am.
হ্যাঁ, ওইটার সাথে WPA ওটার সাথে অ্যাপ্লিকেশনটা একেবারে CN1 of 2024 disposal করে। আর lastly, needless to state, since no affidavits have been called for from the state or the private respondents, the allegations made in the writ petitions are deemed not to have been admitted. Okay. রিপোর্ট হ্যাঁ দিয়ে দেবে। কপি অফ বোথ দ্য পার্টিস দিয়ে দিক, মারামারি করছে আর রিপোর্ট নেবে না।
হাইকোর্ট চলবে। Yes.
FOLK. No.
My lord, I'm for the respondent number 4 and 5. I'm led by Advocate Firdaus Shamim. He is appearing online, my lord.
Your lordship. Lord, in this case, your lordship kindly comes to page 21 below. Page 21, your lordship will find there is a complaint before the
Page
21. 21.
Where is your senior?
Page 21, your lordship will find this is a detailed complaint by the petitioner.
নিবেদন এই যে আমি আপনার ঠিক আছে
On the basis.
এই স্বামী এই আমার একটা দোকান ঘর ভাড়া নেওয়ার জন্য শুধু দোকান ঘর আমি
The private respondent, my lord, respondent
must
filed. There is also a civil suit filed.
ভালো কথা।
Executed the rent.
So whatever case was registered,
Case was registered, my lord. Then, my lord, your lordship come to page 22. My lord, what happened? After that.
Page number 23, my lord. That is their representation. And civil suit is pending, my lord. It is a cruel between.
you answered, sir. What?
The civil case is not a matter at all in this matter.
You answer me. You are not supposed to answer him. You tell me case has been registered.
Their case is registered.
charge sheet has been filed.
Then what are you wanting?
Then my lord, what happened thereafter? Page 22, your lordship filed.
22 years.
22, your lordship kindly read.
My
My lord, what happened?
এইভাবে
My lord, kept
আমি
the
পুলিশ
sub-room
কাছে
under lock and key and submitted a report before this court.
কিন্তু
In this
বিবাদীগণ
regard,
প্রশাসনের
my
নির্দেশে
lord,
তোয়াক্কা না করিয়া
supplementary affidavit
বেআইনি অবৈধভাবে গত তারিখে
directed
4টে
me to
নাগাদ
file a
দেখি আমার উক্ত
supplementary
দোকান
affidavit.
ঘরের তালা
Kindly,
ভেঙে
I am submitting
লুটপাট করে
supplementary affidavit.
আবার সাপ্লিমেন্টারি এফিডেভিট হলে
Yes.
সাপ্লিমেন্টারি ইউ আর গিভিং
Yes, supplementary affidavit, your lordship, see, this is the
ইউ আর ফাইলিং or have you filed?
I not get the copy of the supplementary affidavit. I not yet get any copy of the supplementary affidavit.
I personally given to to be part. Nothing. Lordship, see, this is
So have you filed that?
Nothing.
Lordship, see, this is the
তাহলে দেখবো কি ওরা আনসার দেবে তো have you got a copy of that?
Not yet get, not yet get any.
If I hold against you, I'll give you an opportunity. What is your comment regarding ওটা একটু দিন না দেরি করবেন না
you must find it at page 11.
Yes, have you
For the additional
is the original
Chief Judicial Magistrate, my lord, this is the report at page 11, your lordship sees. The police have submitted information before this court that the shop room is under lock and key. Thereafter, this thing, this incident that happened, they have taken away all these things from my room, my shop room.
Where have you dealt with this one, the supplementary affidavit? Where have you dealt with? Give a copy to them also. চলে আসুন এইটা the report which has been submitted do not deal with the contentions advanced in the supplementary affidavit by the petitioner. Also, a copy of the supplementary affidavit be handed over to the private respondents. Respondent or respondents?
Respondent, my lord.
Respondents,
4
my
and
lord.
5, my lord.
Respondents. আচ্ছা হবে না এখন file affidavit in opposition. Respondent numbers 4 and 5 will file their affidavit in opposition in respect 8 of the writ petition along with the supplementary affidavit. Let the affidavit in opposition be filed. By how much time you will take? 3 weeks?
2 weeks, my lord. 2 weeks, my lord.
By 28th of March 2025, affidavit in reply if any be 4th of April. By 11 তাহলে ওই ছুটি আছে 17th April. There is a 11th I could have given, but the next week is totally holidays actually. That is why I'm making it 17th. By 17th of April 2025, release the writ petition under the heading hearing. কোনো peremptory হবে না আগে on 25.
What happened in this case, my lord? My lord, materials of 2 lakhs, 50,000 has been stolen.
Grateful, my lord.
Then, my lord, police has not done anything.
Afterwards, পুলিশ আর ট্রেস করতে পারবে না, কম্পেনসেশন নেবেন তো রিলিজ। ওই নট পসিবল। কি বললাম অন ওই হবে না on 21st of April 2025 state will submit a fresh report which would deal with the orders passed by the learned ACJM in respect and the accusations made by the petitioner in the supplementary affidavit. Chalo.
Grateful, man.
Report submitted today, we kept in the record.
Service till today, my lord, I am.
আরে এসছে তো আবার affidavit Yes, sir.
Option Kumar Ganguly appearing for the state, my lord. I pray for not today.
Not today. It will be not today.
Then make it on Monday, keep it on Monday. Tomorrow there might be a.
Automatically, tomorrow nothing will be done. After afternoon hours,
Retain its position.
it
only
will retain its
because some
retain its
urgent-
position. Retain its position. Chalo, next then. Not today. Put it in. Put it in.
But I am for the state. I got the report.
বড় মামলা না ছোট মামলা?
My lord, I am appealing for the
Lordship,
respondent number
kindly
6.
come to page number 18. There was a suit filed by the private respondent against me, where I was the defendant number 12. Kindly come to page 18, 12. Wasim Reja. This is the petitioner.
দেখুন সে আগে রিপোর্টই তো 12/12/2024 তো।
Now this
there in the record.
This was
there in the record. This there. 12 December report is there in the record. এটা ফেরত দিয়ে দিন রিপোর্টটা।
Now, Lordship, kindly then come to page 31.
Page 31.
Application under section order 39 rule 1(2) was moved on behalf of the plaintiff there, and now the order was that the instant petition under 82 of the CPC read with 151 of the CPC filed by the plaintiff hereby rejected without the cost. Now, Lordship, here kindly come to the last paragraph. Considering the facts and circumstances and materials on records, it appears this suit.
Which page are you reading?
Page 31, Lordship.
31, your plaint has been returned.
Yes.
Then
Their plaint.
whose plaint? There.
Our
Private respondent.
Thereafter?
my place.
Now, thereafter, Lordship, kindly come to
6.
the order of the executive magistrates which were passed from page 40 onwards. In the meantime, the Beldanga ICPS is directed to maintain law and order, and this order has been extended. Now, I was constructing the house on my own land, which I have purchased. They are
আমি কি
creating
করব?
disturbances.
আমি কি করব?
The police should be directed. They do not have any order in their favor.
My lord, subsequently, I have already
Mr.
filed.
Executive magistrate, I will not execute the order, sir.
Lordship, executive magistrate's order, I'm not seeking any execution of that order. I want the police to ensure that when I construct something,
They will stand
should
and
not-
see a reaction is going on.
They will not. Nobody should create any disturbance. Nobody should create.
এ খালি বলে দিচ্ছি জেনারেল নো কনস্ট্রাকশনে কিছু বলছি না। there is a long standing নিন there is a long standing dispute existing between the petitioner and the private respondents.
I have already filed
Whatever. General order not for general order not for construction anything. আচ্ছা কি বললাম? Petitioner and the private respondents full stop learn a certain order of partition suit has been brought to the notice of the court. However, there is no order of the civil court till date. Since parties are having land dispute or what? You having land dispute?
The land dispute.
That parties are having land dispute. Petitioner and the respondents are having land dispute. Police authority would see that there is no breach of the peace and or tranquility and or any untoward incident resulting from the strained relationship existing between the parties. Full stop. In case any of the parties.
So I lodged a complaint, which is in page 49.
One more, I will
abducted by
for construction করতে গেলে civil court permission লিখে দেবো ওই পর্যন্ত with the aforesaid observation WPA 29402 ওটা কেটে দিন with the aforesaid WPA 29402 of 2024 is disposed of server copy চল
grateful
এই দিয়ে হবে
I'm appealing for the union of
petition.
Mr. Moikukaji appearing this matter, Lordship.
শরীর খারাপ কি হয়েছে?
Lordship, he is not available. Can you keep it on Monday, Lordship?
Not today.
Lordship, Monday.
Not today.
Tomorrow, 2 days he is not available, Lordship. Due to some difficulties.
Not available.
My lord, Mr. Mighty is appearing for the NIA in this matter.
Monday it will be taken
Monday,
up. I'm
Lordship.
just because tomorrow after 2 upgraded matters will not be called. Not today means Monday automatically. You understand? Next is Tati Dakun. আরে কি খবর? 154.
Very small matter, my lord, covered by a lordship judgment.
আমার কোনো জাজমেন্টই নেই হ্যাঁ
Bank fraud, my lord.
My lord, I appear for the respondent number 6 and 8. Lordship, this matter has been filed by suppression of facts. If I may please your lordship.
Who are you?
I am for respondent number, private respondent 6 and 8.
CBI কোথায়? Have you made CBI a party?
Yes.
হ্যাঁ
CBI কে party করনি?
Where is CBI?
Yeah, three and four.
Huh?
But at least in this matter, there is no police in action because there is no complaint before the police.
No, no.
How
The
can the
Lordship.
direction to proceed?
No, state
CBI is a police.
Lordship.
Kindly appreciate this, the prayer. Well,
He was it.
I understand the Bank of Baroda prima facie is a complainant.
Huh.
But subject to correction by your lordship, they cannot have probably any right of audience in respect of choosing the investigating agency. Let them file a complaint before the concerned police station. Well, this I find that a complaint automatically is forwarded before the CBI.
Yes. Lordship, if I may submit, this writ petition has been filed by suppression of facts because the declaration of fraud which has been declared by against the company.
Suppression of fact.
Lordship, if I may, the declaration of fraud which has been declared upon against the company, we had challenged that order before the Honorable High Court via writ petition. The Honorable Justice Shampa Sarkar had stayed that declaration of fraud. If I may hand over the order.
তাই কিছু করার নেই রাজেশ আগরওয়াল
Lordship, please the order.
Declaration of fraud.
if there is no fraud,
there is no the order.
There
has
is
been
no
stayed.
fraud. Why will see? Huh?
এটা mark করা আছে, sir, এটা নিয়ে নিন।
So you have got to contest that, sir.
We will contest.
No, but until and unless that fraud is removed, how can the criminal case proceed?
I will keep this pending.
আরে pending কিভাবে
There is no
রাখবো আমি?
question of keeping it pending, Lordship, because it has been stayed. The declaration has been stayed.
Mr. Rajgupta, get instructions.
FIR registered. My complaint is against the CBI's letter. Kindly see last.
Are CBI's letter arising out of a factual circumstance, sir.
Yes.
Now there is one case of Rajesh Agarwal where, so are you falling within that particular? Otherwise, it's very difficult.
বলছে ওই জাজমেন্টের মধ্যে ফল করছি we are following তাই সেটাই তো বলছি
হবে না ওটা ক্লিয়ার করে এনে এটা তবে হবে
kindly then keep it pending.
month of June.
Lordship, if
And liberty to mention.
আরে বাবা এটা বড় কথা বলেছি
Lordship, if I may file an affidavit to bring
I am
this.
not entertaining the writ petition right now. I am not dealing with this. Until and unless that is clear, if that is dismissed, this is automatically dismissed.
Mention for the time we allow to go out.
List the writ petition in the month list of June 2000. You are wanting to do investigation in nationalized bank cases. এমনি কিছু করতে পারছে না জমি এডিএসআর এর থেকে নোটিশ এনে করতে পারে না কি বললাম the list of June 2025 under the heading motion liberty is granted to the petitioner to mention for listing the same after serving upon the respective parties.
I'm so grateful.
Second submission was like Mr. Torupdar. The second pressure was like Mr. Torupdar. You understand? Huh? Yeah. Record nahi. Any private respondent over here?
Yes, Lordship.
Huh? Where is the affidavit of service, madam? When have you served? After upgradation, have you served them? After upgradation, have you served them? How they will know a matter is being taken up? Which one? That I will consider a Ashok.
My lord, kindly see page number 33 till the
Yes.
till the end, my lord. There are several orders.
Who is the individual?
My lord,
What is the prayer? Mohan?
my lord, Park State Police and authorities are giving liberty.
Already 23 cases are there, madam.
23.
Ah,
My lord, I do not have any idea about these people.
I don't know.
This has been done against these people, my lord. They are violating the court orders, high court
There are
orders,
23 criminal cases registered by Park Street Police Station.
but not to them, my lord. That is different for the demolition of the building, unauthorized building. That time, that is the different thing, my lord.
Up to
For this,
2024. Again in again, it may be
my
even
lord,
some.
in 2024, the case FIR has been filed for the year 22. Because when I approached to the
Wow.
court,
Where the read petitioners resides the restaurant. Most of the local people living in a vacant area. What is your prayer in the read petition, madam?
my lord, I filed this petition and asked for the enforcement of the order because as the state advocate is saying,
Enforcement of which order, madam?
my lord, the all order, page 33, kindly see page
Trying to
33
direct.
till the end, my lord.
Which order? I am not an executing court. Tell me which order.
My lord, from the main petition, page 33.
Page
33, my lord.
Page 28 was a prayer.
Yes, so many orders and all are violating, intentionally violating
Whenever the petition is
by the people of councillor, and Park State Police are allowing them to
the Honorable
violate
Supreme Court also to
and torturing us, my lord.
Yes, when Gallo কি order আছে 33 Justice শিবগ্রামের তো I cannot do anything. Honorable Chief Justice has passed an order.
My lord, they are violating court orders.
41 or 47 এটা 41.
47 also, my lord.
So you go to the West Bengal Pollution Control Board.
They are also the party.
They will not directly act without the direction from the. You see the order, page 41. You have got a copy.
Yes, my lord. And what about
the West Bengal Pollution Control is directed to immediately issue a public notice giving in white that the noise level cannot exceed so and so. So you go for if that is going on, you go for contempt over there. Why are you fighting?
My lord, this is for the judgment passed for the specific reason for the Muharram. And my lord, in page 42, 47, kindly see page 42 and 47.
42 years, which part?
The drug peddlers are staying 24/7 in our area, occupying our area, my lord.
So who are the drug peddlers? Have you named them?
My lord, many complaints I have given, but Park State Police are not at all.
Which complaint names a drug peddler? Show me. From the repetition, you know.
My lord, I have made the party to respondent number 13, my lord. He is.
Where is the information furnished to the police authorities in respect of a particular person who happens to be a drug peddler?
My lord, I filed this petition for the noise pollution because we are not staying throughout the night. Even, my lord, yesterday night, I called 5 times.
Madam, you have got to stick to one prayer. Just explain. If it is for noise pollution, have you served the West Bengal Pollution Control Board? They are the authority to decide. That is what the Honorable Chief Justice.
Petition to them also, my lord. My lord, kindly, my lord, we are dying every day, and Park State and authority are not taking any steps. they are allowing the violators to violate the
This
court
is not the
orders.
domain of, madam, you have gone to the Honorable Chief Justice. Honorable Chief Justice has passed an order. If the said order is violated, the contempt petition will lie. As simple as that. How can I implement? My duty is not to implement the order of another bench.
My lord, that time Park State Police has made 2 fabricated cases against me and threatened me. If you will file any writ petition or any contempt, you will be. We will make fabricated cases. We will file
No, these
series
are
of cases against you, my lord.
you have filed a writ petition, fabricated case has been filed.
No, my lord.
Then,
But my lord, this.
Madam, you have got to stick to a prayer. You are praying for implementation of the orders of all the court. I am not an executing court.
My lord, not even my lord, not a single. My lord, kindly.
Madam, what I'm asking you, you serve the pollution control board and you better file a complaint. I'm keeping the matter pending.
My lord, I
Matter-
serve the copy to pollution control
When?
board also.
When?
It's there.
When?
They are also the party.
When have you served? Affidavit service দিয়েছে? Pollution control board কে কবে দিয়েছে?
It came back to me again. I have served through mail.
You may give a hand service.
All right, my lord.
Give a hand service in the office of the West Bengal.
Yes, my lord.
Petition is directed to serve at the office to effect hand service. To effect hand service in the office of the West Bengal All Pollution Control Board. Acha. Report submitted.
Okay, how the police in action?
My lord
has already taken steps.
My lord, they are the.
I can inaction.
All right, let them come. I will dispose of that.
They are the people of council, my lord. They are torturing every day, every night, my lord.
Madam, I understand, but you have gone up to division bench. I cannot execute division bench order. But I'm just giving an opportunity so that the pollution control board comes.
But my lord, no, it. But
Subsequent to that, no action.
But my lord, then why we are suffering again?
ঠিক আছে কি বললাম? Pollution control and file affidavit of service is on the next date. Release the writ petition in the monthly list of April 2025 under the heading motion.
My lord, just one moment. I want to say something. As the state advocate has mentioned that police picket is there. The civic volunteers, female, are sitting there and they are coming just for 3 to 4 hours in every shift. And they are very busy with their mobile phone. Every day I'm getting threats, abusive language every day, my lord.
Person deciding there.
No.
No other person.
All right, you send your mails to the concerned police station.
Yes, my lord.
And come up before this court. We'll see.
I have my prayer.
Report you will take back. Report submitted by Mr. Banerjee. We kept with the record. Ki holo?
And 2 of iOS officers also present. Can we
Haven't-
support that area?
I dispense with the appearance. Item number. Who is the other side? Who is appearing for the petitioner? Specially weeks matter take to din 1 minute. কেন আসতে বলেছি আমার মনেও নেই, সুন্দর করে মনে আছে, এটা পারপাসের জন্য আসতে বলেছিলাম। হ্যাঁ, বাট কম্পালশন ও এটা সেই কেস ডায়েরি আছে তো। টু কেস ডায়েরি এটাই 205 না? সুন্দরী মন্ডল ও জয়ন্ত আছে। এই রিপিটেড এই সপ্তাহে তো আর হবেও না। কামিং ফ্রম উইচ মালদা থেকে, এর কপাল খারাপ, বারবার আসে আর ফিরে যায়। আচ্ছা
In person করে দিয়ে দেবে।
ফ্রাইডে ফ্রাইডে কত আছে 21st possible please dispensing with the appearance we'll see on that date. I'll ask them to come, huh? Acha, since the officers are present for assisting the learned aid additional government aid pleader, they mean their appear. I'm keeping the matter as it is, asking them if you require you will call them, huh? কি বললাম their father appearance for the timing is dispensed with. If the assistance of the investigating officer is required, Mr. Yusuf would subsequently inform them.
Lord, as we have to item number 150.
আর কিছু হবে না
No, I am not making prayer for taking up today, my lord. Your lordship, as I understand, your lordship is not taking to tomorrow. So let it be after 26, my lord, your lordship.
no now no order can be passed, sir.